Two more witnesses, ma'am.
Huh?
Two more witnesses.
Because the SLP is silent. I lead instruction, it's a fresh matter, but the eyewitness.
So only two witnesses are required to be examined?
Yes.
Huh? In a murder case, we will release you when only two witnesses are required to
The
be
eyewitness
examined.
is not examined as per the SLP. Jagdish Yadav is the person who was with the
No,
defendant.
no, he says
Yes.
that two have been examined.
Yes.
Depositions are on record. It is not appearing because the charge sheet perhaps is not on record.
Record, ma'am. No detail.
So we don't know how many witnesses. He says another two.
Yes.
Let us accept another two. Why should we grant you bail in a murder case?
Your Honor, the three accused persons, there are four accused, three have been granted bail. The person who has not surrendered,
Sorry.
being in anticipatory.
Dismissed.
Your Honor, grant me the liberty to approach the trial court in that case.
Then you withdraw. We'll just simply say dismissed as withdrawn.
I'm great.
Dismissed as
Grateful, my lord. Would my lord permit me to give my appearance, please?
Yes.
Grateful.
Yes, my lord. 5 years, almost 6 years is in.
This is also 302. How many witnesses
only
are
one
proposed?
Only one witness, lordship, complainant. In 23rd March.
You have not annexed the charge sheet. Have you?
Lordship, no.
Then how do we ascertain? You don't say anything. You know, this is the
Lordship.
efficiency in the pleadings. You are seeking bail. Right? You must show what is the progress of trial. Nothing, silent.
Lordship.
Not even a whisper as to how many witnesses are proposed.
Only one lordship.
In a murder trial, only one.
Yes, lordship. Now,
Because from the charge sheet, only one is to be examined.
One examined.
one examined.
One is, say that.
Yes.
How many else are required to be examined?
56.
56. Very well.
He
And all witnesses are fact be examined. Trial court is encouraged to expedite the trial. Dismissed.
Lordship, consider lordship 6 years, almost 6 years. And FIR, 2 FIRs filed in same date.
Yes. Trial court.
Two FIRs.
expedite the trial. We have given that.
Lordship, one person against
On such
20.
a half-baked petition, don't expect an order from us.
Lordship,
Right?
Lordship, within 1 week I
Nothing
will
is
file.
there.
Lordship,
What is your role? We don't get to know.
Lordship,
Because the charge sheet is not
Lordship,
on record.
within 1 week, Lordship, I will file Lordship. Lordship, consider 6 years is almost 6 years in jail. 1 week.
Liberty to file additional documents.
Lordship,
Released in August.
Lordship, he has 11 antecedents and he has not
So this is
disclosed.
11 antecedents, right? I noted.
Lordship, may see para 9.
Sorry, 11 antecedents.
FIR has
Explain that.
There are 2 FIRs filed by the prosecution, Lordship.
Para
One is
9.
20 kilometers distance between 2 FIRs, Lordship,
wait, 20.
and one in other FIR, Lordship. This 4 minutes.
Sorry, recall that order. Dismissed.
Lordship.
Item 4, my lord. 3 years in jail.
Please, my lords.
Petitioner.
Investigation is complete and charge sheet is laid.
So this is NDPS.
NDPS, my
We
lord.
don't treat it as an ordinary IPC offence.
Correct, my lord.
4 bail petitions in 1 year.
My lord, there is something.
What is the change in circumstances,
There
sir?
is something erroneous. All 4 bail petitions have been dismissed on the ground that twin conditions have not been satisfied. But twin conditions will not be applicable because there is no commercial quantity involved.
Why 24 kgs of ganja?
No, my lords may kindly have the seizure memo at page 15, my lords.
Page 15. There are 3 people. You say that there are 3 people.
Page 15, my lords, serial number 5. What is record from me is only 8 kgs, my lord. Page 15, serial number 5, my lords may kindly see. What is record from me is only 8 kgs.
There are 3 persons from whom
3
24 has been.
From me only 8 kgs was recovered. Even this 8 kgs, my lord, we are disputing because the forensic report says leaves and
Where
leaves.
is the charge sheet?
Not charge sheet are not filed. I will file it, my lords. My lords may
Nobody
kindly.
files the charge sheet. You disable us from looking into the
I will
charge
file
sheet
it.
and find out what is the role attributed to you, and then you expect
I
that
apologize.
discretionary
I will file
jurisdiction
it.
to be exercised.
My lords may kindly grant me some time, my lords. I will file it.
Anyway, we'll 4 bails in 1 year. You don't. Why didn't you raise this point before the court? You not
It
raised
was
this
raised,
point
it
before.
was raised, my lords. It is recorded in the impugned order. My lords may kindly have page 2, my lords. Of the impugned order, I have at para 3, my lords may kindly see. third line, the further contention of the petitioner is that the petitioner along with other accused were found in possession of 24 kgs ganja, but each of the accused were carrying only 8 kgs of ganja. Hence, section 37 of NDPS is withheld as each person were containing 8 kgs of ganja, which is an intermediate quantity, but it was not considered, my lords. All 4 petitions are dismissed solely on this ground that twin conditions were not satisfied. Even otherwise,
Show us the first order.
not the very first order. My lords may kindly have it at page 32, my lords. The relevant para is at page 33, para 4, my lords. Last 3 lines, therefore the
This argument was not raised before the court on the first occasion. It's only 24 kgs of ganja. Where is the second order?
lords, it is at page 35, my lords.
Yes, page 35. Where is this point raised?
Lords, para 37 is the fourth para, my lords may kindly see at page 36.
Yes.
Even otherwise, the prosecution case is that each one of them were possessing 8 kgs of ganja, which means intermediate quantity, and therefore rigor of possessing commercial quantity will not arise.
So it was in one trolley bag.
No, my lords, 3 bags from my
In
trolley
a
bag.
trolley bag. In a trolley bag.
Yes, my lords.
In a trolley bag. What is the stage of the trial?
My lords, charges have not been framed.
My lords, I'm appealing on advance notice. My lords are seeking
That will
time.
be framed 1 year.
Yes.
Firstly, within 1 year from date of commencement of trial, if the trial is not concluded, liberty to pay for bail. Dismissed.
Grateful. My lords.
Next.
Because this is the case of gross miscarriage of justice. 20 years I have been waiting, lordships, for my compensation.
Yes.
Grateful, lordships.
May it please go. Milord, after winning the first round, I am now Milord worse off. Milord, let me tell Lordship, Milord, in a nutshell. I have made Milord a small note for your Lordship's consideration because the issue started Milord long way. Give a copy to the court. Give copies please. Milord, it's completely Milord, completely illegal what the High Court has done.
Washing the order.
The rules be applicable.
Yes, that's the only question. Now, Milord, if your Lordship will just have a look at this. See, Milord, see the chart first.
This one.
Just see the chart. So, Milord, left side is, Milord, the mining leases. Right side is the forest clearance. My Lords get that? This is the chart I gave to the High Court also, Milord. It's on record. So, first lease, Milord, 54 to 73, 20 years. Second renewal, Milord, 74 to 93, 20 years. Now, Milord, on the third renewal, this is, Milord, 1/1/2014. Just make a note, Milord.
Yes, 1/1/14.
So, Milord, your Lordship will find on the right side, the forest clearances, Milord, I have got at all times, but they are different, Milord. They are not, Milord, on identical dates. My Lord sees that? That's the problem, Milord, which the government addressed. What happened was, Milord, on 1/1/2014, I didn't get a renewal on 1/1 on that day. So what the government said was, on 29 January, it is not here, on 29 January, Milord, the government said that your FC, though valid, is lapsed because there is no ML from 1/1/14. This ML from 1/1/14 actually came in September 14, Milord, with effect from 1/1. So I said, Milord, that my FC, my lord, your communication that the FC is invalid is wrong. I came to the Supreme Court directly, my lord, because these cases were pending here. This court, my lord, suspended the order of the central government saying that, my lord, there is a gap and you can't mine. That was suspended, my lord, for 10 years. Then the Supreme Court said you better go and file a writ petition. So I went and filed a writ petition. The writ petition was allowed saying, my lord, saying that when you got it in September, it will date back to January, and therefore, my lord, there will be deemed to be a seamless continuance and there is no hiatus. So it continues. Now, my lord, there are two circulars to answer Justice Datta's question. Now, your lordship may leave this. Now, kindly turn to the next page. In 2006, the Supreme Court said you pay NPV, my lord, I paid 107 crores. Now, 29/1/24, what was I was saying, my lord, they issued, my lord, a communication saying that you don't have it from 1/1, therefore your FC lapses. The Supreme Court, my lord, stayed the operation of that order. Mining continued, and on September 14, it was renewed from 1/1/14 till, my lord, December 33, which is 7 years hence. No problem. Now, because, my lord, the dates were, my lord, not matching across India and people were running from here to there, the government came out with the guidelines, my lord, in 2015. Allow me to read that, my lord. Respondent issued guidelines, that is government, central government, which stipulate that the validity of an FC shall be deemed to be extended. You don't need to apply. For a period coterminous with the mining lease, subject to payment of NPV. There was no requirement, therefore, to apply. So, my lord, by virtue of this, and by virtue of the High Court judgment, and with my seamless, my lord, continuance, in 2015, my FC, if your lordship would come back on this, my lord, my FC, my lord, would be deemed to be coterminous. At the end now, the last FC is, my lord, till December 26th of this year. By virtue of 2015 guideline, my lord, subject to payment of NPV, which I have paid as per Supreme Court order, my FC will be valid till December 33, my lord, by a deeming fiction. This deeming fiction, my lord, was in a problem because of, my lord, the 29, my lord, this 29/1/24. My lord sees that. Because of 29/1/24, I did not get the benefit of 2015 in 2015. But, my lord, when it was relegated to the High Court in 2025 has allowed my writ. Justice Anjaria's bench, my lord, and the lordship of the Chief Justice. That has been allowed. Now, my lord, on the same page, my lord, the lordship will find last, same page. The division bench by judgment dated so and so set aside the communication and held that the mining leases will continue seamlessly. Liberty was granted to approach the authority, my lord, for execution. This is ministerial because I have FC, which is deeming, my lord, from 2026, it will go to 33. But I need forest lease, which is ministerial, my lord. So I went to the department. And the department now says that you pay 138 crores and, my lord, buy 900 acres of land and give it to us.
So why do you say that 23 will not be approved?
Correct. My lord, your lordship will straight away see 23, the document. My lord will see, my lord, in volume 2, page 438, my lord. That's a short point. 438. No, sorry. No, 438. 438. I am not showing you 2015, my lord. 2015 has been held in my favor anyway. Kindly turn to 438, my lord. Volume 2, my lord, page 438. These are, my lord, consolidated guidelines and rules. My lord, this is dated 29th December 23. Much after, my lord, I had got, my lord, my things. My lord will see the last line. All the provisions enshrined in, last line, my lord, enshrined in the guideline will be applicable from 1/12/23 prospective. Can't apply to my case, my lord. Second, my lord, the actual guideline then starts, my lord. Your lordship may be pleased to turn to 446. These are statutory. 29th November 23. First, see, my lord, 1-2. They will come into force on 1/12/23 and to cement it, my lord, if your lordship goes to the top in exercise of powers conferred by so and so and in supersession of the rules except as regards things done or omitted to be done. For me, my lord, 2015 would have applied, but for the snag which I faced, which snag was removed by the High Court. Now, my lord, the High Court says, why should not this apply to you? It can't apply to me, my lord. I fought a battle from 2014 till 2025 in the Supreme Court and the High Court. I succeeded. Once I succeeded, there has to be, my lord, seamless extension of the FC till as long as the mining lease is alive. Now 7 years are left, my lord. I don't need to pay anything. I had to pay NPV. My lord may see the 2015 guidelines also. My lord, a few pages earlier and page 400. A few pages earlier, if you lordship. Page 400. This would have applied to me in 15, but for the snag created in 2014, which snag was removed with retrospective effect by the High Court. And the High Court judgment is final. My Lord Justice 400, my Lord.
English in 1954. Right. Forest Conservation Act was not there.
Correct.
Forest Conservation Act came into force from 1980. Certain obligations accrued which you had to discharge. Similarly, 2023 guidelines impose certain new obligations.
They are only for,
Why will you say
because
that it will not
because
apply?
they are only for those, my Lord, who are applying in 23. I didn't have to apply.
Why?
Because I am covered. I was showing you.
This is for protection of environment, Mr.
But I have done whatever was required. I don't have to, my Lord, just have a look. See, kindly see page 400, my Lord. I was showing you 2015. Just tell to 400 for a second, my Lord.
400.
400. This applies to me admittedly. The High Court in the first round held this applies. And it is admitted, my Lord. I show you, my Lord, one by one. I haven't shown you the High Court judgment as yet. My Lord will see 1,415. Your Lordship will find, this is the subject. See, my Lord, paragraph 3. After careful examination, I am directed to say that in the case of existing mining leases, which are mine, specified in 8A1 as inserted by the amendment, amendment will not extend the validity. Period of approval, validity of approval, according to section 2, shall be extended and shall be deemed to have been extended up to a period co-terminus with the lease in accordance, my Lord, subject to the condition that I will pay the NPV. I paid the NPV, my Lord, as per the Supreme Court's order in 2012. And this, my Lord, this would have taken my FC valid.
Does this 1st April 2015
Yes.
not stand superseded by the
No, my Lord, come back to 438. Very important question.
446 is issued in supersession of the Forest Conservation.
Correct, but just have a look, my Lord. Just have a look
Just a
again.
government order, executive instruction. This is just an executive instruction. How can it survive?
How can a prospective document apply to somebody, my Lord?
No, this is,
See the saving also. Let's see the saving. 446 top, my Lord.
tell us.
Yeah.
Then this logic would have applied even in 1980. That why are you insisting that I should require a forest license to be obtained?
No, my Lord.
Because I have got the mining lease from 1954.
True, but my Lord, there was no concept of forest till the Act came, my Lord. Till the Act.
Sorry, Mr. Rodhu, we are not inside.
My Lord, your Lordship may have a look at the judgment of the High Court, my Lord.
You've seen.
My Lord, I have succeeded and ultimately landed back in the same problem, my Lord.
We feel 2023 has been rightly held to be applicable to you. Next,
My Lord, I wanted to show you the exception at 446 again. It says, my Lord, except as regards all things done or omitted before the supersession.
thank you. Yes, who appears? Appearance is willing to be referred to mediation,
Yes, Muluz. I am for the husband, Muluz, respondent 2, Muluz. I'm seeking a pass over, Muluz. No.
willing to explore mediation.
No issue, we'll do that.
No issues?
Yes,
Well.
Muluz, because one child is with him and one child with me, Muluz. A senior mediator may be appointed because there are issues between the parties, Muluz.
Senior mediator.
Great.
Would Muluz give us a date during this vacation period so we can utilize this? Yes,
Matter will be returnable in August.
where will it?
either in May or in June, the direction will be given.
Grateful.
Please, my lords, I'm appearing for the petitioner wife.
Yes.
My lords, the service has been complete on 30th of March 2026, but nobody has turned up
No
on the other
appearance.
side.
Hello.
Obliged.
Plus 12 appear for the
I
petitioner
was
wife.
requesting for a Passover.
Lordship, may I just request one thing? They have filed a counter, there are certain amendments which are being made. I need to rejoinder. Their Lordship, permit me a week's time. I file my rejoinder to that effect, Your Lordship.
But in the meanwhile,
In mediation as failure, Lordship, we have explored the possibility. Yes, before this honorable court has mediation sent as failure, Lordship.
Land Council appearing for the petitioner seeks and is granted 2 weeks' time to file rejoinder affidavit. Released in August. Stay to continue.
Please, madam.
Right.
Please, madam.
Mediation bills. There are multiple proceedings pending, so let that mediation happen for all the.
Which one?
Item 10.
Item 10.
So there are 3 other cases, so it may not be limited to only this case.
Mediation may not be limited to the dispute raised involved in the transfer petition, and the senior mediator to be nominated may
My lord, in
attempt to bring about a mediated settlement in respect of all other pending disputes.
And so,
my lords, in item 11, can I have the order dusty, please?
Item?
11. Can I have the order dusty, please? Transfer petition has been allowed.
It has been allowed. Why dusty? The records have to be transferred, then you,
No issues.
not in this man.
Lordships,
Yes, 13.
item number 13, I will request for the mediation, Your Lordships.
Who appears for the petitioner?
Your Lordship, I am seeking a Passover in this matter.
Willing to explore mediation?
Yes, Your Lordship.
Very
Will much obliged.
Yes. Next, 14 adjourned as per letter.
request for mediation in that matter, 14 serial number, lordship.
Item 14. Who is for the other side? Respondent? Respondent has asked for adjournment.
Yes, we have no objection, Lords. No objection, Lords. Lords, let the matter be referred to mediation, Lords, in the meanwhile, Lords.
The online mediation, both parties are from outside.
Although a letter has been
Deeply obliged.
circulated on behalf of the respondent seeking adjournment, at the time of call, Land Council appearing for both parties submit that they are not averse to exploring a mediated settlement. Yes. Bring it up in August.
Lordship,
Stay to continue. Stay if you need to continue. Yes, 15.
Lordship, the divorce petition filed by the respondent is allowed by the learned trial court. Therefore, I am withdrawing.
Infractuous. Submits that transfer petition has been rendered infractuous, disposed of as such.
Much obliged.
Next.
May please, Lordship. This is my application for anticipatory bail, my lord. 26.
26.
Please, my lords. Admitted case, my lords, of the prosecution itself, that I was not there in Mahendragarh on that date, my lords. I was doing my duty here, my lords.
We are not there.
Yes,
183 statement of the victim is there. Sorry,
I'm here for the bail, my lords.
dismissed.
Contents of FIR. May I withdraw it, my lords?
Dismissed as withdrawn.
Grateful, my lords.
Not interfering, we will request the High Court to decide the criminal petition within 3 months.
But there's no head and tail match between the two FIRs.
Huh?
Two FIRs are totally different.
Wait.
Matter the investigation.
Let them hear the petition. That endures to your benefit also. Impress upon the court that this is absolutely a frivolous criminal petition, should be dismissed immediately.
If I can.
It is listed in the High Court.
Look into it.
5th of June, it's listed in the High Court.
But my lords may say that my lords have not gone.
Having heard Mr. Raju, learned additional solicitor, appearing for the petitioner, and Mr. Kohli, learned senior counsel for the respondent. And considering the fact that the criminal petition is listed for hearing on
5th of June, Lord.
5th of June 2026.
All petitions, there are 4.
Criminal petition along with other petitions are listed on 5th June 2026. We are not inclined to interfere at this stage. Special petition is disposed of with a request to the High Court to decide all the petitions before it as early as possible and subject to its convenience. Positively, subject to its convenience by August. All contentions are left open.
Nothing on merits.
All contentions are left open.
Deeply obliged, Lordship.
करेक्शन कहाँ बोला आपने? Appropriate and just in the factions and so on. We are not granting any further indulgence to the judgment debtor. The decretable property has to be vacated by 30th June 2026 without fail. At the same time, we decline the request of Mr. Call at this stage to revise the amount payable. In terms of the order of the High Court, the trial court under Order 20 Rule 12 will determine the amount to be payable. The judgment debtor may rely on the report of Shetgiri. Mr. Call can raise all possible objections which were raised before us. And after hearing the parties on their own merits, the inquiry court will dispose of the matter.
Oblige, my lord.
Oblige me.
ये भेज देना ऑफिस में. 29.
My lord, I am requesting for a short date, in fact. The person, in fact, could not come today. So he has made a request to moderate it.
What do you want? Adjournment?
I'm in 29, my lord.
Yes, we have called on 29.
It's 29, I'm in the 29.
Yes,
From the petitioner side.
yes.
The person concerned, in fact, has to come all the way from Calcutta, and he says that you just ask for the, just make a request for the adjournment.
So why should we adjourn hearing? Because the petitioner wants to be here. He could have joined online.
He is not well aware of it. He is not techno-savvy, man.
Huh?
He is not very techno-savvy, my lord.
He is not very tech savvy.
Yes.
So we will have to wait for him. When will he come?
No,
Then
not-
we will take it up.
Not that, my lord. He has made a request if it,
He has made a request. Now, this is coming on a mention memo.
yes.
You mention it before the Chief Justice. Chief Justice places the matter and he is not there and we will have to adjourn.
So that is what he has asked me to do, sir.
You are the counsel. You should have told him.
I have
But this is
already,
the Supreme Court. Supreme Court doesn't wait for the client to come from Kolkata to Delhi
yes.
and then in his presence take up the matter.
Not in,
Then why are you there?
oh, he has simply engaged me just to file the case.
Simply engaged you to argue the matter.
So let me argue the case, in
Of
fact.
course, you argue the case. Show us where is the error in the order of the division bench.
My lord, in fact, the only thing is that I'm not a escapist. I'm not absconding from paying the amount to the bank.
Look here, you have approached the writ court under 226
Yes, my lord.
with a prayer that extend the time for making payment under the one-time settlement,
Yes,
right?
yes.
The High Court says, I don't have any such power.
No,
Now, if you say High Court has the power, you have to show where does the High Court derive this power of extending the time for honoring the one-time settlement?
my lord, in fact, the single bench of the High Court simply said that, okay, you have got the, you are being given the time to settle the matter. And then the respondent approached the division bench of the High Court, and High Court said, no,
Where you show us the error in the order.
my only point is, my lord, that
There is a judgment,
Ji.
incidentally authored by me on behalf of a coordinate bench, where we have noticed previous decisions of the Supreme Court and we have said that court has no such power. It's a one-time settlement. If you fail to honor the settlement, you have to suffer the consequences.
my lord, I have paid 67.
This is a contract between the two of you.
Yes,
And the
two.
court extend the time.
Court may extend the time for.
No, why? What's the power? Court will extend the time.
Because, you know,
They have given you certain terms that on these terms, one-time settlement can be worked out.
so
Correct?
just
Now you fail to honor the terms. Why will they agree?
they have locked the factory, so our work is not going
And
on.
now you go before the 17 forum and challenge. Right?
Yes, my lord.
We have been apprised by learned counsel appearing for the petitioner that he wished to remain present in court when the special writ petition is heard and decided. Since he has not reached court, a prayer for adjournment has been made. Stop. We record that the court cannot wait for the litigant to reach the court to witness court proceedings. Stop. We have heard Mr. Swensel and counsel for the petition and are of the considered opinion that the division bench of the High Court has correctly observed that the court has no power to extend the time for working out the one-time settlement reached by and between the secured creditor and the borrower. So, the order of the division bench under challenge does not suffer from any error, and therefore the special writ petition is dismissed. So we have additionally recorded what you submitted.
Okay, my lord.
May I please, Lordship? One request, Lordship. The other connected matters are coming up tomorrow. The main matter. If this SLP can be taken up, okay, with those matters tomorrow, because it has far-reaching consequences.
Tomorrow.
The state is also fair.
18458 SLPC
They
184.
will give you
Yes, once we filed it, we mentioned it to come up tomorrow.
with the other matter too.
Please, sir.
Huh?
My lords, in item 31, I'm requesting for a passover.
Well,
My lords, the senior is on.
it was there on Tuesday. We adjourned it. Maybe it was not called on yesterday, but today again Passover.
My lords, the senior is on.
Passover. But remind us before we rise.
Yeah, please.
Specific order was passed.
We are in 31, madam, which we have passed over.
No, my lords, 32 is Shilpa Goldie Su.
No. Shilpa Goldie Sood is 31. We have passed it over. 32 years, Mr. Singh. Where are the
Got the latest information provided
Yes,
by the Subordinate Service Election Commission. I just passed it on. I've got only one card.
Right, before my management passes on, 23rd of November, Lordship's framed questions.
23rd of
November, last year, which was part heard. And those questions pertain to the vacancies of 2015, 16, 17. Now, this news story is being spun up that it never applies to the court. 5 adjournments took place.
That in-
That the new selection process has started.
Okay, I'm
Some, part heard matter was like violation of law.
Just one more thing to add to what Mr. Mukherjee said. There was a question raised in the UP Assembly. There, the state government clearly said that total sanctioned posts as on 2023 was 7768, out of which vacant posts are more than 5,000. More than 5,000.
Dikhaiye. Give the other copy. Second copy. Discussion, second copy.
Okay.
Acha, you have.
we kindly have the order for
Okay,
the last day.
Second page is the English translation, my lord. More than 5,000 vacancies. And there's no recruitment post 2023. As on.
So saying if this is right, we do not know whether this is right or wrong.
What I said is,
If
on the
this
last
is
day,
the statement in the well of the assembly.
left out vacancies of 2004 advertisement. They were advertised in 2022. But in that month, there were a number of 406. Out of 406, my lord, now 2,406. But this was the Lordship last order, my lord.
File your written submissions before court partial working days. Judgment is reserved.
Obliged.
Lots, in item number 32.2, we have two implement applications.
1 week. 1 week to file.
We are giving you more than 1 week.
Lord,
We are closing on 29th March,
much obliged.
29th May. So we are giving you more than 7 days. 10 days time you have
Much obliged.
written submissions by 29th.
Obliged.
My lords, in
I appear for that commission, my lord.
Acha, UP Commission.
Only on the factual part, my lord.
Yes. Just 1 minute.
Yes.
Mr. Mukherjee and Mr. Singh.
Yes, commission.
Lord, I provided the information to Mr. Singh. Lord, there were 2,406 posts, out of which,
Left out.
as per the order, my lord.
No, that is what he submitted. We have recorded.
Yes, the total number post is correct. My lord, the unfilled post was 555, not 675.
Lord, and those 555 pertain to various categories, Lord. I have prepared a detailed chart, Lord. I'll file it with my submission.
But what about this answer in the assembly that 5,000 are vacant?
That I
Have you seen that?
Yes, Lord, I just peeped over it from.
So we are also granting you liberty.
Yes,
You may not be a party to the proceeding
I am, Lord, in one of the matters.
in one of the matters.
Yes, Lord.
So you tell us
Yes, Lord.
in your written note whether this, what Mr. Sen has just now placed before us is right or wrong.
Yes, Lord. I'll take instructions on that.
We are passing this order. You come back on Monday and tell us
Lord, they,
on instruction.
Lord, this commission.
On instruction, just tell us whether, because if it is wrong,
Yes, Lord.
then we will have to
Yes, Lord.
put the matters back and rehear.
Lord, actually, the vacancy will be under different recruitments. So I will give that detail. I'll get that detail.
Monday,
Yes.
Justice Masi may not be with me,
Yes, Lord.
but we grant you liberty to come and say
Yes, Lord.
whether this question was put in the assembly by one legislator
Yes, Lord.
and whether the concerned minister gave this reply or not.
Yes, Lord.
If it is yes, one consideration. If it is no, different consideration.
I understand, Lord. That's the reason why, Lord, I'm making this commission. Lord, I just wanted to clarify, Lord, the role of the commission is that we receive requisition from the department.
We know your role.
Yes, yes.
We know your role.
Yes. On
Mr.
the,
Singh, you can also obtain instructions and then let us know on Monday.
Yes, Milord. Milord, sir,
32.2, may I say this, Milord? Milord, we have filed an intervention application along with directions. One is, Milord, 95986 and 95986.
All intervention applications we will deal later.
Milord, we are also.
We will deal later. Let us first get the information on Monday. Then we will consider, because you may be all fence sitters. All fence sitters. Now filing for impleadment. Very difficult.
But the commission will also take into account the 23rd of November. So that
We will consider. All impleadment applications will be considered.
sir, whatever. Yes, sir.
Huh? Reserve. Monday they will just come and mention. Monday they will come and mention. And if possible, Mr. Mukherjee, Mr. Sen, your juniors may be present in court.
Yes, yes.
Because if they come and say that this is incorrect information, then whoever has supplied that information will be taken to task.
It's on that now. But anyway, I think it's the correct information. Whereas Monday, I think it will be virtual. I think
Monday will be virtual.
Lord, it's actually optional. In the sense
Monday
that
will
it's
be
not-
virtual, right? You are right. So all of you be there.
We'll show our face.
Lord, I'll Lord, try and send a colleague, Lord, so that can be handed over. Grateful, Lord.
Very well. 33.
My lord, the state was directed to seek instruction
Lordship,
whether
all-
they have filed 65B certificate on record or not, my lord. On the previous.
All documents are already on record, Lordship. I have checked it. I'll argue on merit, Lordship.
My lord, may I submit, my lord, specifically directed state to whether they have filed on the record, trial court record, 65B certificate or not. Specific, my lord, he was directed. But I have filed, my lord, the original records in separate room, my lord. There is no certificate available on the records, my lord. They have not filed.
If I may, Lordship. I'll explain.
Just give a brief outline of the matter.
Yes. My lord.
Student of class 12.
My lord, I'm just. My lord, the incident was happened on 25th of December 2015, my lord.
Yes.
And on the same day, my lord, the father of the complainant filed a complaint. That is at page number 27, my lord, which doesn't reflect my name, petitioner name, my lord, first. Thereafter, my lord, the same day, the police reached at the spot and in the said incident room. Thereafter, recovered the one suicide note, that was the original, my lord, and one Samsung mobile, my lord. And after searching whole the rooms, my lord, and that was seized, and there were two witnesses, they signed, and father and mother were present there. My lord, that is, that suicide note also doesn't contain my name. That is the original one, my lord, that is on the record. I'm not questioning on that. But thereafter, my lord, the second complaint was filed by the father, which also doesn't contain my name. FIR doesn't contain my name, my lord. My name came in during the investigation, my lord. Thereafter, my lord, kindly see page number 41 CDR, my lord.
You were also not named in the charge sheet.
Yes, my name was came during the investigation, my lord, but I was exonerated because of my lord, IU didn't file anything. Even as per the CDR, there was no call details between me and deceased, my lord. There's nothing on the record. That's why, my lord, my name was deleted from the charge sheet. Thereafter, my lord, their cases, they said that these articles, chip, by the one chip they found, wherein they found the one photocopy suicide note and one audio, my lord. They filed, my lord. They said the police refused to take. Thereafter, I filed this after 2 years, my lord. This is their case.
Clarification. Police filed the charge sheet.
Yes.
You did not figure as a charge sheet accused.
Yes.
The complainant, did he file any protest petition?
No, my lord. No, nothing.
Nothing.
No protest application, no during the charge framing, no.
So now you have been summoned under 319.
Yes, directly, my lord. Based on this article, my lord, without support of 65B application, even summoning application doesn't support any affidavit, my lord. Kindly see there, my lord. Should I show the summoning application first? My lord, kindly see the.
Please just complete the narration in the list of dates.
Yes, my lord. Thereafter, my lord, kindly see the.
We have come to charge sheet petitioner not named 5th of December 16.
Yes, my lord. That's correct.
Then trial court frames charges.
Thereafter, my lord, one person number 11 was filed in the charge sheet, which thus correlated CDR of mine and deceased, my lord. They specifically. Yes. Thereafter, my lord, they clearly stated that there's nothing, no CDR, no details, no calling with the petitioner, with the deceased, my lord. There's no connection with that. Thereafter, my charge sheet was filed, my lord. The trial was commenced, charge was framed against the Pintu Sarkar. He's the main accused, my lord.
Right.
And thereafter, my lord, on 18th of May 2017, PW1 testimony was recorded.
Yes.
My lord, he is the father of the deceased, wherein, my lord, he is just silent.
About
In
your role.
chief examination, he is silent about these chips, all these things. And thereafter, my lord, PW2 also deposed there. She explained
Who
during
is
the
PW2?
mother of the deceased.
Mother of the deceased.
My lord, PW1 is silent. He doesn't know. He didn't depose anything during the chief examination. I'm not coming to the cross examination, my lord. PW2 stated the story of chief, my lord, after 2 years from the date of the FIR. Before that, they didn't raise this particular issue during the framing of charge. They did not file the protest application. They did not question about the further investigation, all these articles, my lord. Their case is, my lord, they said that the police refused to take these articles and they said you should produce in the court. My lord, even they denied this aspect, I never given this particular article to the police during the cross examination, my lord. They given this particular articles to during the opposing the bail before the High Court, my lord. I may kindly see the summoning application, my lord. I want to show, my lord, kindly see the page number. Page number 68, my lord, kindly.
Page 68.
Yes, this is the summoning application. After 2 years, just with the planned manner, they have moved. This is the moved by the PW1, father of the deceased, my lord. Can I see? Even they did not describe about the chip, about the audio recording, my lord, nothing in this. Even there is no detail about the details of the chip, which company, capacity of the memory, my lord, whether it is readable or not, nothing else, no description. And also they have said, that is on the record, my lord, they have said the chip was broken. I do. My lord, kindly see the page 70. This is the order of the court that is on the record, my lord, 7th line. Archana Gupta broken memory and was found tore in the language when she came home. My lord,
Reading which page?
page number 70, my lord.
70.
This is the order, my lord, wherein they are asking that just I want to put the audio clips and chips on the record, wherein it is there is a, my lord, kindly see the 7th line. Archana Gupta, a broken memory card was found tore in the language when she came home. My lord, the chip whether chip was readable or not readable, how they restore the data. My lord, in these circumstances, the certificate, this is the kind of secondary evidence, my lord. It is a case of no evidence. My lord, without any certificate, there's nothing, my lord. This order was passed. Thereafter, in this matter, they were directed to just their chips were taken on the record. My lord, kindly see the page number 72, bottom. At this stage, the chip has been filed from the list dated so and so, the application so and so be listed for in so so. Even there is no, my lord, there is no 65B application because they are relying upon these evidences to implicate me, my lord, at the stage of 319. There must be a strong evidence. And thereafter, my lord, they have filed one audio recording which is between the Pintu Sarkar, my lord, main accused and deceased. That is that is also not supported by any certificate, my lord, whether that is true, false, my lord, can you see? Even, my lord, that's not considered with me also. Everything, my lord, depend on the chip, my lord. They have found suicide note. That is the photocopy of suicide note. The original is not on the record. It is my case, my lord. And this is the articles, my lord. That is the conversation between the Pintu Sarkar and deceased. I do not have any concern, my lord. They are relying upon over this, my lord. My lord, even the summoning application is not supported by any affidavit, my lord. There is nothing, my lord. I have filed, my lord, all the order sheets, my lord, between the relevant period, my lord. They have not sent even the trial court did not ask status report regarding these articles, my lord. Nothing is on the records. My lord, that's why, my lord, my case is that the summon was issued contrary to the my lord, the judgment and parameter laid down in Hardeep Singh, my lord, case 105 and 106 paragraph, which says there must be cogent and strong evidence, my lord, at the stage of 319. My lord, this is the, my lord, if I believe PW1 and PW2 statement right now, based on the chip, that cannot be also relied upon, my lord, here. So this is my case, my lord. That's why, my lord, the trial court committed error issuing summoning without any certificate, without any strong evidence. It is a clear case of no evidence or
Yes.
My lord, I want to refer judgments on the point. My lord, my case is clearly, my lord, there is no strong at this stage of 319. My lord, to whom I should corroborate. My lord, if my lord, if someone is justified rightly, my lord, to whom I should corroborate during the examination, my lord. There's nothing on the record, my lord.
Which judgment you want to rely on?
My lord.
Hardeep Singh.
My lord, Hardeep Singh and
First, only Hardeep Singh is enough.
One more judgment here also.
The Constitution bench judgment.
Yes, yes, my lord.
You have a compilation.
Yes, my lord.
Very well, hand it over. Yes, madam.
Lordship. The entire argument that the order was based on the chip is misconceived, Lordship. His argument is that the application under 319 was allowed relying upon the chip which was not supported by a certificate under 65B. So the examination of that order is very important. Bare reading of the order would show that it clearly says that the chip was taken on record. However, it was not proved. It relies upon the deposition of PW1 and PW2, where clearly...
It's the deposition of PW.
Yes, Your Lordship. The deposition of PW1 and 2 starts at page 49. I will point out the paragraphs, Lordship.
49.
Page number 49 is the statement of the father.
Yes.
If your Lordship may permit me, page number 50, where the role of the petitioner can be culled out. I'll just read it. Last line from page number 49. At the time, Ragini and her daughter met, and Ragini took the mobile number of my daughter, and by calling regularly, Ragini used to get her husband Pintu Sarkar and her friend Sonu, that is him, to talk to my daughter Archana. All three used to talk obscenely with my daughter and used to invite her to meet outside. They also used to come at the room of my daughter. My wife had also told these things previously. Therefore, I called and scolded Pintu, Ragini and Sonu. Again, his name is there. Sonu, son of Munib Jaiswal, is resident of so-and-so. Pintu often used to talk obscenely from his mobile to my daughter, which she used to tell to her mother. Ragini had made an obscene photo of my daughter by calling at her beauty parlor, in which Pintu and Sonu were also involved. So complicity of the petitioner is clearly made out from statement of both PW1 and PW2. Even PW2, if your lordship may permit me, I will point out, starts at page number 57.
Does the suicide note implicate him?
There are two suicide notes, lordship. One has Pintu's name and the other one has Pintu and his name.
So one was pasted on the wall.
Yes, your lordship.
Where did the other suicide note come from?
Lordship, it is the case of the complainant that she was a student, a minor, 17-year-old child. She was raped multiple times by these three. Ragini.
By the three? Ragini?
The Ragini was running a beauty parlor. She was also complicit. And it is the case that when the parents went after her death, when the parents went to her place where she was residing, they found a bag in which there was a chip which was found with 15 audio recordings. There was a photograph and there was a suicide note which was found from inside her bag. They went to the police, who refused to take the evidence, and that is why it was brought on record later by the complainant. That is their case, lordship, the complainant's case.
Did the chip surface for the first time?
The chip surfaced for the first time after 2 years, from what I understand.
Lordship, may I am for the complainant, Lordship. Lordship, the articles of she was living in a student and living in a rented accommodation. So police recovered at the time of inquest. Thereafter, her articles were taken home. Then there was a one bag. And in one bag, after around 1.5 years after that, these things.
It's very unfortunate that you have lost your daughter. But when you take back belongings, is it believable that after 1.5 years or 2 years, you will be searching the bag and trying to find out what is there? Huh?
Lordship,
the proof has to be more than prima facie. Stronger than prima facie, as per Hardeep Singh.
Lordship, they approached the police.
Why did you not file a protest petition? When the charge sheet did not indicate that Sonu is not being arraigned as a charge sheeted accused, what were you doing? You say in your examination that Sonu was harassing your daughter.
Lordship.
You knew everything. Why didn't you file a protest petition?
Lordship, because the police, when we approached the police did not take and said you approach the court. Meanwhile,
the
bail
protest
application
petition is not before the police. Protest petition is before the court.
My Lordship, these are not so aware litigants, my Lordship, poor persons.
No,
and
you
if
say
the advocate,
page 50, sir. See your evidence. Page 50, you have scolded Sonu. You say that Sonu was on talking terms with your daughter. He used to talk obscenely with your daughter, and for which he was admonished by you. So you knew this before your daughter passed away?
Lordship, this is...
and still you don't file a protest when Sonu is not arraigned as an accused.
Lordship, this is father's testimony, and he was informed after the death by the mother. Mother was aware, but she has not disclosed to her
Sir,
husband.
please, you don't make submissions contrary to the evidence. Please come to page 50. Therefore, I called and scolded Pintu, Ragini and Sonu. Either you don't know Sonu or you know Sonu. Please see page 50.
Lordship, if Lordship may permit, Lordship, the entire thing about the incident, it was only means what little bit was informed, and therefore he has scolded that they are harassing, but he wasn't aware about
Come
the.
to page 51, paragraph starting, I have not met Pintu Sarkar before this incident. And you say that I called him, warned him.
He has not met, but he has called on
How did you scold and warn him?
on phone, Lordship,
On phone, three of them together.
telephonically. He has not met.
Judgment reserved.
My lord.
Lordship, I wanted to place a case law, if I may.
Lordship,
Please file your written submission
Lordship,
by Monday.
grateful.
CAV.
May please not. Lord, if your Lordship permit, I'll give a brief recapitulation of what we had argued last time. I am the petitioner.
Yes, Mr.
Now, my lords, the point here was, before I take your lordships to the list of dates, very briefly, the point was that, my lords, I am an award holder. They are the award debtors. I filed an execution, my lords, just on the cusp of, my lords, coming of the Commercial Courts Act. My execution, my lords, for some reasons, remained pending before the learned principal district judge, who, my lords, for administrative reasons, transferred it to the family court, who was also a district judge. So, my lords, there were sales, there were auctions, there were objections by them, everything was decided by that court as an execution court, my lords, after the award. There 34 in the meantime came to be filed and dismissed by a detailed judgment, my lords. There 37 is pending under defect for more than 1 year, I am told. They have not, my lords, brought it up for hearings. Now, my lords, there were 4 orders which were passed by the learned execution court with regard to some auctions and sales, which I'll tell you lordships in detail. My lords, 3 revisions came to be filed by them before the Honorable High Court, and 1 revision came to be filed by me on merits of the matter, my lords, on merits of those orders by the learned execution court. Now, the Honorable High Court, by way of the impugned judgment, my lords, relies on Delhi High Court and, my lords, Honorable, which is the other one, Kerala High Court. We have placed a compilation of all judgments against us and in our favor, my lords, saying that the commercial court only had jurisdiction to, my lords, hear an execution post an arbitration award. Therefore, whatever has been done till date by the execution court, which was not the commercial court, has to be effaced from the record. It's quorum non judice, everything is null and void. So all orders set aside. I have to pursue my execution afresh after all these years in the commercial. Lord, this is the summum bonum of the proceeding so far. Lord,
Just set aside on execution in this case.
so everything was set aside, and Lords, the impugned judgment says all execution orders passed in the state, Lords, will be set at nullity. I'll show that. So, Lords, we have quickly, if I can just, Lords, recap the provisions, because before I come to the impugned judgment, the provisions of the Arbitration Act, Lord, and the Commercial Act should be very relevant. Our submission was that after the award, the arbitration proceedings, Lords, are terminated as per section 32 of the Arbitration Act. Thereafter, section 36 says that execution will be treated as if it was a decree under the CPC. And therefore, Lords, secondly, Commercial Courts Act, when it amends CPC, Lords, for its applicability of different provisions to the commercial courts, then, Lords, it ends at order 20. It does not take it forward order 21 onwards. So even the Commercial Courts Act, Lords, leaves execution of an arbitration award or of any other decree open for being executed, Lords, in the civil court. So, Lords, this was our submission. A quick purview of all the provisions, Lords, very quickly I will read them, so that, Lords, the point I am wanting to make, I can, Lords, then. Please have the Arbitration Act, Lords, to begin with.
And also the convention.
Judgment compilation.
Partition has already been carried out.
But Lordship may have section 2, subsection 1, clause E. Court means. The issue will be, Lord, the Commercial Court Act says suit or any application. Arbitration, no doubt, a commercial dispute, Lords, I'll show from the Act. But suit or an application. So the Honorable High Court Division Bench in our case says, Lords, in the impugned judgment, that execution is also an application. Now, my lords, please have section 2(1)(e). Court means in the case of an arbitration other than international commercial arbitration, the principal civil court of original jurisdiction in the district and includes the High Court in exercise of its ordinary original civil jurisdiction, having jurisdiction to decide the questions forming the subject matter of the arbitration, if the same had been the subject matter of a suit, but does not include any civil court of a grade inferior to such principal civil court or any court of small causes. So, not like, for example, in Delhi, even the Honorable High Court can be, Lord, subject to pecuniary jurisdiction, the principal court of original jurisdiction. In Haryana, it will be the learned district judge. Now, my lords, the Act envisages several applications. Like section 8, if a suit is filed, despite there being an arbitration agreement, my lords, so somebody can file an application under 8. Section 9, my lords, is interim measures, lordship knows. Section 11 is appointment of arbitrators, etc. Then section 16 to challenge the jurisdiction, and all of these applications, my lords, are applications, is our humble submission. Now, please have, my lords, section 21. My lords, is commencement of arbitration with a notice, and then please have 32. My lords, is termination of proceedings. This is the section we are, my lords, humbly submitting and pressing upon. The arbitral proceedings shall be terminated by the final arbitral award or by an order of the arbitral tribunal under subsection 2. In our case, award was passed, so proceedings, lords, came to an end except 34 and 37. Then your lordships will kindly have, my lords, 34 of course is setting aside, which they filed and it has been dismissed. Then please have, my lords, section 36, which says, my lords, enforcement. Where the time for making an application to set aside the arbitral award under section 34 has expired, then subject to the provisions of subsection 2, such award shall be enforced in accordance with provisions of the CPC in the same manner as if it were a decree of the court. Not, please mark this.
The arbitration was amended after the Commercial Courts Act. This provision was not amended. 2016 it was but it was.
Yes. What is important is, lordship may mark in the footnote of the Bear Act, this section 36 was amended. Lordships will recall, not earlier 34 was a per se stay. Then 36 was amended to say that court will impose conditions. This amendment comes after the Commercial Courts Act, lords, has been put into enforcement. No, it's the same date.
Yes.
It's the same date, I'm sorry, lords. 23-10-15 Commercial Courts Act and 23-10-15 this section 36 is also amended.
Bouquet of amendments.
The act is called Act of 2016, but it came with effect from 23-10-15. So it was a bouquet. Lords, even then, this provision, my lords, is not mentioned to say that it will only go to the Commercial Courts Act. The execution, I mean, lords, which is called enforcement, lordship knows, lords, when it comes to an arbitration award.
Arbitration. How to come.
This, lords, was the scheme of the Arbitration Act. Now, lordships, please have, my lords, the Commercial Courts Act. Lordships, is not section 1 subsection 3. It's the same date on which the Act 3 of 2016 amending the Arbitration Act was enforced. Same date here, my lords. Section 1 subsection 3, my lords, it says it shall be deemed to have come into force on the 23rd day of October 2015. Now please see section 2, my lords. Small b, 1b says commercial court means the commercial court constituted under section 3 subsection 1. Commercial dispute means a dispute arising out of. Your lordships have read this several times, lords. Arbitration will come later. I will show that, lords, we are a commercial dispute, no doubt. Then, lords, section 3 is constitution of commercial courts. The state government may, after consultation with the concerned High Court by notification, constitute such number of commercial courts at district level as it may deem necessary for the purpose of exercising the jurisdiction and powers conferred on those courts under the Act, provided that with respect to the High Courts having ordinary original civil jurisdiction, the state government may, after consultation with the concerned High Court, by notification, constitute commercial courts at the district judge level. In our case, my lords, the Honorable High Court is not a court of original jurisdiction.
So what is the date of the award?
The date of the award, my lord, is 13/10/2015.
13/10/15.
Yes, my lord.
Date of 34 dismissal is?
34 dismissal is, my lord, 2000, my lord, no, just give us a moment. It is 2025. We have placed that, my lords. Section 34 was dismissed on 29/4/2025.
29/4/2025.
And the dates relevant for section 3 are given by the Honorable High Court, my lord, at page 34 of the paper book.
Ten days before this act.
The next section is section 6.
Yes.
Jurisdiction of commercial court. The It says, note, the commercial court shall have jurisdiction to try, please mark notes, all suits and applications. So anything which is in the nature of a trial relating to a commercial dispute of a specified value arising out of the entire territory of the state over which it has been vested territorial jurisdiction. Explanation: for the purposes of this section, a commercial dispute shall be considered to arise out of the entire territory of the state over which a commercial court has been vested jurisdiction, if the suit or application relating to such commercial dispute has been instituted as per the provisions of section 16 to 20 of the CPC 1908. Number lordship may only mark, normally such a statute can also have a provision that the civil court jurisdiction is excluded altogether. Lord, there is no such provision in this act. No, section 10.
Yes.
Then lords, arbitration is commercial is section 10 of this act, jurisdiction in respect of arbitration matters. Of course, this has to be above the specified value, which is 3 lakhs not, so there is no dispute in our case, it is above 3 lakhs. Section 10 says jurisdiction in respect of arbitration matters. Now please see 11, lords. This is the reverse exclusion, bar of jurisdiction of commercial courts and commercial divisions, notwithstanding anything contained in this act. A commercial court or a commercial division shall not entertain or decide any suit, application or proceedings relating to any commercial dispute in respect of which the jurisdiction of the civil court is either expressly or implicitly barred under any other law for the time being in force. Now, my lord, lordship may kindly have 12, lordship may leave, my lords. 13 is also appeals. Please have, my lord, section 15. I'll read, my lords. Please go ahead. Chapter 5 itself says, notes, transfer of pending suits. Then section 15, transfer of pending cases. All suits and applications, including applications under the Arbitration and Conciliation Act 1996 relating to a commercial dispute of a specified value pending in the High Court where a commercial division has been constituted, shall be transferred to the commercial division. Now this, in my humble submission, lords, was to be done by the Honorable High Court on the administrative side. If it thought that, my lords, only a commercial court would have, my lord, jurisdiction to hear executions pending all across the state, not only my execution, my lord. This was never done.
Yes.
Milord, similar is subsection 2, all suits and applications, including applications under the Arbitration and Conciliation Act relating to a commercial dispute of a specified value pending in any civil court in any district or area in respect of which a commercial court has been constituted, shall be transferred to such commercial court. So since the Honorable High Court, there is not ordinary jurisdiction, civil jurisdiction, therefore 2 will apply. All execution should have then been transferred, Milords, by the Honorable High Court. Provided that no suit or application where the final judgment has been reserved by the court prior to the constitution of the commercial division or the commercial court shall be transferred either under 1 or subsection 2, where any suit or application including an application under the act relating to a commercial dispute of specified value shall stand transferred to the commercial division or commercial court under 1 or 2, the provisions of this act shall apply to those procedures that were not complete at the time of transfer. This is important, Lords. I will show you Lords why. Please have subsection 5. In the event that such suit or application is not transferred in the manner in subsection 1 or 2 or 3, the commercial appellate division of the High Court may, on the application of any of the parties to the suit, withdraw such suit or application from the court before which it is pending and transfer the same for trial or disposal to the commercial division or commercial court, as the case may be, having territorial jurisdiction over such suit, and such order of transfer shall be final. Now, why that is important is, I have said about the Honorable High Court. The other side, not the award debtors, also never filed an an application to the Honorable High Court saying that this execution is wrongly going on in the court of the learned district judge. It was for the first time. I will show to your Lordship, Lord, and your Lordships have held in 2023 and recently. That means, if you do not take an objection, first time in the High Court on the appellate jurisdiction not allowed.
Yes.
Lord, section 16. Chapter 6 says, Lords, amendments to the provisions of CPC. Now here, Lords, the distinction comes how, Lords, commercial courts will expedite, Lords, the commercial suits. Section 16 says, amendments to the Code of Civil Procedure in its application to commercial disputes. The provisions of the Code of Civil Procedure shall in their application to any suit in respect of a commercial dispute of a specified value stand amended in the manner as specified in the schedule. The commercial division and commercial court shall follow the provisions of the CPC as amended by this act in the trial of a suit in respect of a commercial dispute of a specified value. Please mark note, trial of a suit, where any provision of any rule of the jurisdictional High Court or any amendment to CPC by the state government is in conflict with the provisions of CPC as amended by this act, the provisions of CPC as amended by this act shall prevail. So, my lords, please see the schedule now, which is after section 23.
Yes.
Lords, I only have to submit for the schedule that when your lordship reaches towards the end of the schedule, my lords, your lordships will find it ends at order 20. Please see clause 11 of the schedule, my lords. So the schedule, lordship knows, provides for how, say for example, beyond 120 days in a commercial dispute, no written statement come what may. Similarly, it has been amended for other provisions of CPC. So the last provision is, lords, clause 11, amendment of order 20. Lordships will find clause 11, lords, of the schedule. Clause 11 is, lords, amendment of order 20. Lordship, this is Masih has. Now it says, lords, amendment of order 20. In order 20 of the code for rule 1, the following rules shall be substituted, etc. After this, lords, giving one appendix of statement of truth, the schedule comes to an end. So order 21 and thereafter, lords, for us it is order 21 execution, which is a complete code in itself, is not referred to by the Commercial Disputes Act. Lords, the object is to expedite. If executions were to be, lords, undertaken with a different procedure, this act would have mentioned it. So it does not really matter whether the learned district judge, lords, decides an execution or the learned commercial court. There is no distinction in the act. The Honorable High Court says the object was to expedite. I am rather being set back, lords. Now, my lord, this was about the scheme of the provision. Section 9, of course, I do not need to cite. Section 9 CPC is not the classic example that civil court will have jurisdiction, my lords, unless specifically excluded. So this act does not specifically exclude. Now, my lords, we'll take your lordship through the impugned judgment. It has only relied, my lords, on the Honorable High Court records their submissions, my submissions, then, my lords, relies on two judgments. My lords, we have given a compilation last time. We have placed all the judgments there, my lords, in our favor and contrary. If your lordships can just take that, my lords, I'll quickly take your lordship through all the judgments.
First, let us see the impugned
judgment. I'm grateful. Now, my lords, the background of the impugned judgment, I told your lordships at the outset. In my execution, my lords, there were two properties which your lordships will call properties A and B. For those two properties, I, as the award holder, myself purchased them for about 6.5 crores, and that was allowed to be set off against my decretal award. That was one order which they challenged. I'm just giving your lordships the background so that it becomes easier to appreciate the impugned judgment. The second order challenged by another party was, my lords, that there were two properties called D and E, which were in the nature of, my lords, windmills. That auction had also happened, but the learned execution court, my lord, decided the third party objections against me, saying that I did not have territorial. So that was my revision, which I filed. Two revisions, my lord. Sorry. Now, my lord, so the third revision by them was that with respect to A and B, after the auction, my lord, is accepted and their objections are dismissed, sale certificate is directed to be issued in my favor. So that was the third revision. And the fourth revision was against the ministerial order of issuance of sale certificate itself. So these were the four revisions, my lords, in the pending execution before the Honorable High Court. Now, my lords, please have the impugned judgment. Starts at page 1, my lord. Contentions are recorded. Lords, his contentions are summed up in page 13, para 11, and his judgments are also cited, my lord, which I will just immediately cite, lords, after I complete reading. Lords may see para 15 at page 15, my lords. The contentions of learned counsel can be summarized as under. These are their submissions. The value of the award is above 32 crores. It is far above the commercial value, no dispute. Since the commercial court at Vijayawada is constituted to exercise jurisdiction over the district at Anantapuramu, the EP cannot be entertained by the 7th additional learned district judge Anantapuramu, and the said court lacks inherent jurisdiction to pass orders. He submits that as it is a case of inherent lack of jurisdiction, he can question the same at any stage, and therefore he has raised the issue before this court. Then, lords, in reply, our submissions start. These are essentially what I have submitted before your lordships, my lord. And then, lords, the analysis will start. Lordships will find page 23, bottom, lords. Para 20, this is analysis of a submission.
So the analysis starts at 18 of the existing, page 18, para 18.
Yes. So page 18, my lords, the analysis had started. Lordship may come to after reading the provisions. Para 25, my lords, page 23, bottom.
Yes.
A reading of these sections and amendments in seriatim shows that intention of the legislature was only to modify and streamline the procedures and practices relating to suits and applications in suits, etc., which are pending for disposal. The heading of chapter 6 of the act is amendments to the provisions of CPC. The amendments to CPC refer to the first schedule and specifically to orders 5, 6, 8, 11, 13. And in addition, a newly corporated order 15A is brought into force. All of them deal with the trial and disposal of a suit only. This is what we are saying. None of the other provisions of the CPC are touched or amending, including Order 21 CPC. In the opinion of this court, this deliberate silence, now this is important, this in our humble submission is not in a way judicial legislation. In the opinion of this court, this deliberate silence by the legislature, in spite of the need for a law on the subject for quick and efficient disposal of the cases, including commercial disputes being on everyone's mind, makes it very clear that the legislature in its wisdom decided to speed up the trial and disposal of the cases in the commercial court alone. Time and again, the Honorable Supreme Court of India and various courts have spoken about the need for quick disposal of domestic and international commercial disputes. Lordship, then skip a few lines, Lords. Page 25, top. Second line from the top, Lords, page 25. The silence or failure to refer to Order 21 does not mean that the commercial court cannot execute a decree. Our alternate submission is commercial court may, if the Honorable High Court feels, but civil court cannot. That's wrong. A purposive interpretation has to be given to the provisions of the Act. If it is not so interpreted, the commercial courts will be powerless in many aspects. If the arguments of learned senior counsel for respondent are further extended, and as other provisions of CPC are also not touched upon referred to, it would mean that the commercial court cannot add or delete parties because Order 1 it says is not included, cannot bring on record the legal representatives Order 22, cannot grant injunctions Order 39, order attachment or arrest before judgment Order 38 and so on. These are a few illustrative aspects that are touched upon. This would virtually render the commercial courts non-effective and virtually defeat their purpose. Can it be said that since Order 38 or 39 are not mentioned, the commercial courts cannot grant an interim order? This would lead to a collapse of these courts. Now please have, Lords, para 31. This will be, Lords, page 27.
All executions set aside. These are all applications which are connected to the suit.
Yes, my lord, I am grateful. So if I file a 39 1 and 2 has to go to para 31, my lord.
Only the constitutional court which can entertain execution after special all notice transfer.
Para 31.
Para 31, my lord. In our case, in every case. This will be at page 27. Lord. Further, in this court's opinion, the word application occurring in section 15 of the Act is also not limited to original applications or only or to application in suits. Support can be drawn from the provisions of Order 21 CPC itself dealing with execution. Order 21 rule starts with the words application for execution. Rule 11 says an oral application is permissible. Order 21, Rule 11 talks of a written application. Similarly, Rules 11, 8, 12, 13, 16 talk of applications for execution. The use of the word suits and applications, including applications under the Arbitration Act 1996, make it clear that it is not merely limited to suits and arbitration applications only. An inclusive definition is given to include all applications under 15. The intention of the legislature is also clear from a reading of section 10 of the Commercial Courts Act, which deals with applications and appeals under the Arbitration Act. They are dealt with under this section. The court therefore holds that the word application in section 15 includes execution applications also. The inclusive definition in section 15(1) makes this clear. Then Lord, section 36 is cited. Then these are judgments which will just immediately come to, my lords. Now please see para 35 at page 31 bottom, my lord. There cannot be two courts, fora, one for the dispute resolution and one for execution of the decree passed. The Act itself makes a distinction. It stops at Order 20. Section 38 of CPC clearly states that the decree may be executed by the court that passed it or the court to which it was sent for execution. Therefore, this court holds that a commercial court can execute a decree passed by itself or even execute a decree sent for execution under 15 of the Commercial Courts Act or by transfer from another commercial court. For all of the above mentioned reasons, it is held that the commercial court has jurisdiction to execute its own order or a decree transferred or sent to it where the value is above the limit. This court respectfully agrees with the views of the Kerala and Chhattisgarh High Courts. Now here, it seems to be a factual error because the Honorable High Court has done actually the reverse. Kerala and Chhattisgarh are in my favor and respectfully disagrees with the views taken by the other learned judges of the Gujarat, Delhi. Gujarat, Delhi and Rajasthan are against us. Then Gujarat is cited, against which it is said that the SLP has been dismissed. No doubt by a limine order it has been dismissed. Now please have Lords para 42. Page 34 bottom, Lord. Lord, these are the facts on which all this controversy surrounds. Para 42, Lord, bottom of the page. Award on 13-10-15, 23-10-15 the Act comes into force. 18/1/16, post the act, no doubt, I file my EP, my lords, before the learned district judge. On 10/6/16, now this is important, my lords, GOM issued by the state of Andhra Pradesh, by which all the principal district and sessions court were designated as commercial courts in Andhra Pradesh. On 16/5/19, GOM 78 was issued constituting only 2 commercial courts in the state of Andhra Pradesh at Vijayawada and Visakhapatnam. It is therefore clear that by 18/1/16, when EP was filed, the commercial courts were not formally constituted in the state of Andhra Pradesh. On 10/6/16, all the courts of the district and session courts in Andhra Pradesh were designated as commercial courts. From 10/6/16 till 15/5, this should be 2019, Mulaj. This is a typographical error. This position continued. However, with effect from 16/5/19, only 2 commercial courts were designated over all the 13 districts. The family court Anantapuramu was entertaining the EP consequent on the transfer by the learned district judge on 27/8/19. Therefore, the matter was pending before the 7th learned ADJ Anantapuramu. In view of the conclusions arrived at by this court that it is only the commercial courts that have the jurisdiction and authority to execute the judgment and entertain the EP, this court has to hold that with effect from 16/5/19, it is only the commercial court at Anantapuram which could entertain the execution petition or pass orders. No other court could pass orders in view of the conferment of the exclusive jurisdiction on the commercial court. Then, my lords, page 37 is where we argued that they have participated, and I'll press on 2 judgments for this, my lord. That was rejected. Page 37, if your lordship sees, about 7th line from the top, my lord. Other cases to argue that defect of jurisdiction strikes at the very root to pass the order, and that participation of the revision petitioner or the failure to raise an objection will not clothe the family court Anantapuramu with jurisdiction. He also argues that the question relating to such inherent lack of jurisdiction can be raised in any proceeding, etc. That is accepted, my lord.
So on pass.
Yes, ma'am. Then, lords, para 52 is the operative part. The 51, it says inherent lack of jurisdiction. That's fair, lords. I have to point out because judgments will say something on it. And then para 52 says, in view of the power vested in this court, sorry. इसके बाद
So you take exception to this reasoning of the High Court?
Yes, my lord.
By referring to 15/5?
Yes, my lord.
That it was his duty also?
Yes, my lord. Either the court should have sent, my lords, in my humble submission by an administrative order. It's not only my case in my humble submission, my lords. Everything will be affected. Although I am not holding brief for them. But then 15/5, even he had, my lords, the power. And it's the learned civil court versus the learned commercial court.
Now, where is the consideration of 15/5 in the judgment?
My lord, some provisions are not considered.
15/5 not
considered.
15/3 was considered. 15/3 was considered.
What about 15/5?
That doesn't find mention, my lord. But then, my lords, I'll be able to explain from the scheme of that it's in consonance.
The act very good, but 15/5.
But ultimately, my lords, by consent, this point was argued.
Obligation. Both the parties.
Who, my lord?
Both the parties.
But then the CRP was pending. The CRP itself, we have taken a plea that these issues are pending, therefore hold on. But then they went ahead, my lords.
No, why? Is there any stay?
There was no stay. That's what the trial court says. But then the fact remains, the point has been taken.
You are an award debtor. You file a 37 appeal. Your appeal, there is no stay. And you want that till such time your appeal is decided.
No, in the meanwhile, no, in the life, assets are being sold out.
Consider, Mr. Suresh.
Yeah, so sure.
Consider. Yes.
So, my lord, operative part says, para 53, add, my lord, page 40. The commercial court alone is competent to execute decrees which are above the specified value. The regular civil court will not have the jurisdiction to entertain such EPs with effect from 16/5/19 in the state of Andhra Pradesh. It is only the commercial court Vijayawada or Visakhapatnam which can entertain the EPs if they are above the specified value. Now, my lords, the part which, my lords, I said I am most aggrieved. All orders passed after 16/5/19 are orders passed by a quorum non-judice. They suffer from an inherent lack of jurisdiction and they are held to be per se bad in law. Pending EP shall be transferred to the commercial court Vijayawada and both parties are given liberty to start the proceedings afresh and de novo from the said. So in view of that, all 4 CRPs, even my CRP was allowed, saying that yes, you are right, the order should not have been passed at all. To that extent, all 4 CRPs, lords, were allowed. In the meantime, lords, I will not trouble you with too many facts. On 25% deposit, they came up to the Honorable Supreme Court in view of the change in regime in 2016. The learned execution court said deposit 25%. The Honorable High Court set it aside. We have placed all those orders. The Honorable Supreme Court, my lord, said nothing doing. You must deposit 25%. It goes back to section 34 in terms of BCCI judgment. Even then they don't, my lords, deposit 25%, and nonetheless 34 is decided. So that's on facts, my lords, that they have not deposited a single rupee.
Well, what are the decisions?
Yes, my lords. My lord, we had handed over a compilation. Lords, to begin with, please have Sundaram Finance.
No, you will not be referring to all 31.
No. We have marked, my lords, about 13. Those also quickly we will.
Just indicate which are.
My lords, I'll just indicate, my lords. What they say, I'll indicate, my lords. Sundaram Finance at serial 15.
Serial number 15, yes.
My lords.
Then?
Not directly on the point, but this honorable court said that a decree, my lords, the deemed decree of the award.
No, you will take us to the judgment.
Yes,
we are just only identifying.
Yes, my lord.
Which of the 31 you are going to?
Only 13. Only 13, my lords, and quickly. Please.
13 and 15.
No, only 13 number of judgments.
13 out of 31.
But very quickly, my lords.
So which are these? Just
serial 15, Sundaram Finance, my lords, is the first judgment.
Yes.
Lords will see, my lord, Sundaram.
No, we will see Sundaram later on. Just give us the list of 13.
I will do that, my lord. Then the second judgment we wish to cite, my lords, is serial number 18.
18 next.
Then, my lord, the serial number 3 would be serial 13. Which is
13.
Honorable Chhattisgarh in our favor.
Very well.
Serial 11, Shaji Augustine is Honorable Kerala High Court in our favor. Then serial 12, my lords, again Honorable Kerala High Court is our fifth judgment. Then lords, sixth is serial 3, first page of the index. This is a contrary judgment of the Honorable Orissa High Court.
No, this is SCC.
Oh, sorry, I'm sorry, SCC. No, I'm sorry, my lords. I saw High Court of Orissa. I'm sorry. Yes, SCC, my lords. It says something else, but we'll show that, my lords. Then serial 5 is a seventh judgment, Vijay Cotton, Honorable Gujarat High Court. This is contrary. Then, my lords, Honorable Rajasthan High Court is serial 6. This is contrary, SK Finance. Then, my lord, serial 7, Delhi Chemical is what the Honorable High Court has relied upon. It's a division bench, my lord. This will be our 9th judgment. Then, not serial 8 is again Honorable Gujarat High Court. It is contrary to us. This will be the 10th. Serial 9, OCI Corporation, against which SLP has been dismissed, my lord, is also contrary to us, Gujarat. And then serial 10 is the classic judgment of Dhulabai on section 9, my lord. Now, my lords, in none of these judgments, they are all in the facts of their case. No doubt, Honorable Gujarat and Honorable Delhi and Honorable Rajasthan. They have said that applications includes the word execution. But the fact situation was not such, my lords, that everything was set aside and de novo execution was to start. It was against different orders passed in the course of an execution. And then, lords, we've just missed one judgment, serial 26. It's an old judgment of the Honorable Andhra Pradesh High Court Division Bench of 1987 before this controversy. But nonetheless, we'll show that it said that applications does not mean to include executions. Serial 26 notes, P. Bhagwanulu. Executions are independent.
26.
Serial 26 note. It's a 1987 judgment, Division Bench of the Honorable same High Court, which has passed the impugned judgment, to say that execution and applications are different.
Serial 16 and 29 are the same judgments?
Lord, serial 16 is, my lord, Dipali Biswas. 29. Yes, that is it. I'm sorry for this. One is an online version, one is INSA version. Please exclude 29. But not these others.
You are referring to the same judgment twice in the compilation, but you are not going to refer to.
No, I'm not referring to other judgments because these were on merits. All the other judgments are on merits because there is a conundrum for us, my lord. What happens to the orders passed by the learned
Mr.
execution?
Gupta,
Yes.
we are short on time.
Yes, my lord.
All 13 we will not look into.
Don't, my lord.
Just show us the Supreme Court judgments.
Yes, my lord.
Other judgments, we assure you, we'll look into while we.
Lord, I am grateful. So, my lord, Sundaram, page 171 of the compilation.
171.
171. Lord, I must tell your lordships, not directly on this controversy, but it says that when award is passed, then the execution, my lords, can go anywhere in the country, of course, provided it has jurisdiction. But, my lords, the entire statutory scheme was seen. Please have page 182. What we wish to rely upon was that section 32 arbitration proceedings are terminated. So thereafter, it does not remain a commercial dispute at all. Page 633 of the report, 182 of the compilation, my lord.
182.
Para 17. What has been lost sight of is section 32 of the said act. Then after section 32, lordship sees the aforesaid provision provides for arbitral proceedings to be terminated by the final arbitral award. Thus, when an award is already made, of which execution is sought, the arbitral proceedings already stand terminated on the making of the final award. Thus, it is not appreciated how section 42 of the act, which deals with the jurisdiction issue in respect of arbitral proceedings, would have any relevance. It does appear that the provisions of the said code and the said act have been mixed up. Then conclusion, lords, is para 20, page 183 of the compilation. We are thus unhesitatingly of the view that the enforcement of an award through its execution can be filed anywhere in the country where such decree can be executed, and there is no requirement for obtaining a transfer of the decree from the court, which was a precept earlier, which would have jurisdiction over the arbitral proceedings. The effect is that the view taken by the Honorable Madhya Pradesh High Court and the Honorable Himachal High Court is held to be not good in law, while views of the Honorable Delhi, Kerala and Madras, Rajasthan, Allahabad, Punjab, Haryana and Karnataka reflect the correct legal position. So, Lord, this was on termination with respect to our argument. Then, Lords, serial 18 is Charan Properties.
Page.
This is page 198 of the compilation, Lord. It follows Sundaram and in a honorable 3 judges bench combination, Lord. Lordship may only mark, Lords, para 40, where it reiterates Sundaram, and I will only read, Lords, just above para 41. Only para 41, in fact. Until 41, it was Sundaram. 41, in the present case, the arbitral award, in a sense, postulates the transmission of shares from the appellant to the, I'm sorry, page 2 to 6, Lord. Para 41, down below. In the present case, the arbitral award, in a sense, postulates the transmission of shares from the appellant to the claimant. The only remedy available for effectuating the transmission is that which was provided in section 111 for seeking a rectification. There is therefore no merit in the challenge. And Sundaram, Lords, has been reaffirmed.
Now, how is this 41 relevant for our case?
Lords, consequently, in view of the court,
41 does not lay down any law.
No, it's just above 41. I'm sorry.
Bottom of 40.
Yeah. And that Sundaram Finance, Lords, I have read, Lords, the only purpose is this Sundaram Finance has been reiterated, Lords.
Just above 40.
Above 41, yes.
That is the only reason.
Yes.
Now, Lords, please have serial 13 Southeastern Coalfields, page 160 of the compilation. It's a short order, but in our humble submission, it captures the point. Division bench, Lords, as his lordship then was. Please, Lords, para 3. Para 3 at page 160 bottom. In the case at hand, the award was passed on 26/9/2003 and thereafter appeal against the said award preferred by the present applicant has also been dismissed. At present, execution is pending before the district court in the form of an application under 36. Even if the word application is mentioned in subsection 2 of section 15, it would mean an original application and not an application for execution of the award, which is preferred after the award has been delivered. It is not disputed before us that at present, after dismissal of the applicant's appeal against the award, no further proceedings, etc. That lordship must give notes. Page 161. Para 5, be that as it may, once the award has been rendered, the proceedings at this stage have become final and an application under 36 for execution of the award cannot be treated as an original or independent application, dehors the main arbitration proceedings in which the final award has already been rendered. In our opinion, in view of the proviso to subsection 2 of 15, the execution application cannot be transferred to commercial court. Now, Honorable Kerala High Court at serial 11, Milords, page 139. Learned single judge, Lords, 2021, page 139. Please see, Lords, page 150, bottom, para 27.
Let's go column.
Lords, para 27, bottom of page 150 of the compilation.
Yes.
It says, Lords, as observed earlier, the procedure for execution is not mentioned anywhere in the Commercial Courts Act, and there is nothing to indicate that the jurisdiction of other courts with respect to pending execution matters stands excluded. The absence of provision regarding execution or specific exclusion of jurisdiction of other courts with respect to execution procedures and the conscious omission to amend Order 21 CPC for hastening the process of execution can only lead to the conclusion that the word application in 15(1) does not include an execution application stroke petition, and the words those procedures that are not complete at the time of transfer in 15 of the Commercial Courts Act does not take in procedure relating to execution of decree stroke awards. For the aforementioned reasons, I respectfully disagree with the dictum laid down by the Honorable Gujarat High Court in Jagmohan insofar as it holds that commercial court at the district level constituted under subsection 1 of section 3 of the Commercial Courts Act would be the court competent to execute decree awards declared under 34 of the arbitrate. In the decision of the Honorable Delhi High Court in Vijay Cotton, that is also we have placed notes, is with respect to the definition of commercial dispute under section 2C of the Commercial Courts Act, as no argument was advanced by either side on the question whether the dispute falls within the meaning of commercial dispute. I am not venturing to answer that question. Then Lords, the Honorable High Court relies on Sundaram Finance, and then Lords holds accordingly. Similar is, I will not read, Lords, another learned single judge of the Honorable Kerala High Court in 2023 at page 153.
Equally elaborate reason, slightly different, but equally elaborate reason. JC was a very easy to I told him relied on JC.
Yes. Now, the Honorable High Court, and I will leave, Lord, the judgments against me to be cited by my learned friend. I have placed them in the same compilation. I have made your watches mark that, Lords, to save time. Please have page 24. I just want to distinguish this Honorable Court's judgment, which was cited against me, Lords, and relied upon by the Honorable High Court, is page 24 of the compilation, 2023 1 SCC 549. It's called, Lords, JC Housing versus Registrar General.
Yes.
Lords, para 14 is the distinction in itself. I'll just read para 14, Lords, at page 31. Para 14 says, Lord, the question of law arising for consideration in the present appeal is whether in exercise of powers under section 3 of the Commercial Courts Act, the state government can confer jurisdiction to hear applications, please mark, Lords, under section 9, 14 and 34 of the Arbitration and Conciliation Act 1996 upon commercial courts which are subordinate to the rank of the principal civil judge in the district, contrary to the provisions of section 21E. Execution was not the issue here. These applications are no doubt, and they have in all states, Lords, gone to the learned commercial court. And then, Lords, para 28 and 29. At page, Lords, 36. It says, Lords, para 28, if the submission on behalf of the appellants is accepted, in that case, though with respect to other commercial disputes, the applications or appeals shall lie before the commercial courts established and constituted under section 3 of the 2015 Act. With respect to arbitration proceedings, the applications or appeals shall lie before the principal civil court of a district. There cannot be two fora with respect to different commercial disputes. Under the circumstances, notification issued by the state of Odisha in consultation with the High Court of Odisha to confer jurisdiction upon the Court of Learned Civil Judge designated as commercial court to decide applications or appeals arising out of arbitration under the 1996 Act cannot be said to be illegal and bad in law. On the contrary, the same can be said to be absolutely in consonance with section 3 and 10 of the 2015 Act. Second compilation.
Yes.
Now, just to conclude, This Honorable Court, my lords, recently, relying on 2023, has said that, my lords, if you don't raise a point, of course, my lords, jurisdiction, in my humble submission, my lords, three types: pecuniary, territorial, and subject matter. Pecuniary and territorial, it has been held, my lords, once you don't take an objection, you don't take an objection. Lords, the law was that subject matter jurisdiction, even if there is a decree upheld till this Honorable Court, even in execution, somebody can say that you didn't have jurisdiction to pass this order. Now, Lords, in my submission, this is slightly diluted to say that if after a long passage of time, this should not be done. Only for that purpose, we are citing these two judgments, Lords. I'll only make your Lordships mark one para. Please have, Lords.
Calcutta Improvement Trust versus some Ray, R-A-Y. It could be Surajit Ray or something like that. Madam ko bolo to? नहीं. Justice Sabyasachi Mukherjee.
Now, Lords, in this, please see page 76 of the compilation. The issue was not civil court or the work tribunal. The suit went on in the civil court. In the first appeal also. In the second appeal, first time submission came that it was only the work tribunal which should have heard the issue before Lords Sajada Nasheen and Mutawali. The Honorable High Court accepted that and said that the matter should be reheard by the work tribunal after so many years. In those facts, please have para 31 at page 76 bottom. Lord. Thus, in view of the aforesaid discussion, we are of the view that civil court has jurisdiction to entertain the dispute involved in the present case. Therefore, the trial court has not committed any error while adjudicating the dispute. Even otherwise, it is required to be observed that at this stage, it is the contesting respondent, the original plaintiff, who filed OS 92 before the concerned civil court, in which the present petitioner filed written statement and filed his counterclaim. And after considering the evidence adduced by the parties, the trial court decided the matter in favor of the present petitioner. During the pendency of the suit before the concerned civil court, the case was transferred to the tribunal. So and so the said case was registered before the tribunal. Thereafter, the tribunal transferred the case to the civil court once again in the year 2002. And ultimately, as observed herein above, the concerned civil court, after considering the material, decided the issue in favor of the present petitioner. It is pertinent to observe that the order of the tribunal transferring the case to the civil court has not been challenged by the contesting respondent, and the said decision has attained finality. Further, at the relevant point of time also, the plaintiff herein did not raise the objection with regard to jurisdiction of the civil court. In the regular first appeal, herein they did not raise the issue of jurisdiction before the first appellate court also. And for the first time, the issue of jurisdiction of the civil court was raised in the second appeal. And then in para 33, Lords, the Honorable Court relies on Mumtaz. Mumtaz in turn, Lords, relies on Indore versus Development Authority. And in all these paras, what I have told you, Lordships, that Lords, inherent, subject matter, territorial and pecuniary. So please have page 83 bottom. This is in all fairness, I must point out. Para 33 of the cited judgment in this judgment, Lords, is at page 83 bottom. We would like to consider one more issue by drawing a distinction between institution and adjudication. Institution of a suit before a forum where an adjudication process is the same as the other, insofar as the rights and liabilities are concerned, has got no relevancy when subsequently either an act or amendment has been brought forth conferring the jurisdiction to some other forum. In other words, the issue for consideration is the forum to adjudicate. This principle is subject to the rider that it may not have an application where there is already a decree where a party has not raised the issue of jurisdiction at any point. Now, Lords, three jurisdictions is at page 86 top. I have said it, Lords, I will not repeat it. Lordship may only mark. And then, Lords, just to conclude, page 91 is the other judgment of Mumtaz, where, Lords, the court has said that actus curiae neminem gravabit. The duty of the court is also, Lords, to check jurisdiction, not just the parties.
Which paragraph of this decision?
Yes, Lords. Page 106 is para 20, where section 9 and Lord relevant judgments.
Page 106.
Yes, Lords. Para 20.
20.
Yes, Lord. That talks about section 9. But please have page 111, para 25. It says, Lord, page 111 of the compilation, Lord, at the top is para 25. It says, Lords, having dealt with the above said principle and making it applicable to the courts in India, we are inclined to hold that any failure on the part of the court to do so would draw the legal maxim actus curiae neminem gravabit. No one shall be prejudiced by an act of court. As a consequence, in a case where a court has failed to check its jurisdiction and a plea has been raised subsequently, and that too after receiving an adverse verdict, the forum shall not be declared as the one having lack of jurisdiction, especially when there is no apparent injury otherwise to the rights conferred under a particular statute. And then para 27, Lords, at page 115 talks about Zulabai.
Yeah.
Calcutta Improvement Trust Act.
Solution not
Calcutta Improvement Trust Act.
Else,
Lords, only page 115, para 27, Lords, bottom.
115.
115, Lords, bottom of the page, para 27. Para 27, Lords, bottom of the page.
Page
Page 115
115.
of the second compilation, Lords.
Oh, second compile. Just see whether this judgment helps you or not.
Lord, we have taken it out. We have taken it out, Lord.
How did you know?
Lord, the mic is a giveaway. Your lordships were referring to Calcutta Improvement Trust and the honorable judge, so
You have to be very careful.
It's like council sometimes close down the mic, the speaker, perhaps your lordship may also.
No, we may be discussing something very secret and confidential that will go to you.
Lord,
Very, we are quite loud.
I'm an art now.
The movement we can understand. But not this.
Yes, it's big.
We could be discussing many personal things.
It's fitting, yes. Those we will not disclose in any case. That we are correct. 115 bottom, para 27.
So just think of this.
Yes, ma'am.
There are different kinds of lawyers.
Yes, ma'am.
Some lawyers, evoke trust and confidence to such a level that if you say one thing, we will never ask you to open the file to show where you have pleaded it.
Yes, ma'am.
But there may be mischievous lawyers,
Yes, ma'am.
right?
Yes, ma'am.
Who make submissions which are not to be found in the four corners of the petition.
Yes, ma'am.
Now today, suppose I tell my brother that be very careful about this lawyer. What?
He will hear it, ma'am.
Huh? He can raise a point of bias. You accuse. Nowadays, anyone and everyone raises such pleas, accuse.
Yes, ma'am. During virtual hearings, we saw the honorable judges would switch off the mic while speaking to them, Lord. We saw that, Lord. We have TV saw that.
The lesson for us, we learn every day, and this is a new lesson.
No, we are sorry if, Lord, we.
No,
sorry, but that was only to.
Actually, very thankful to you.
I'm grateful, Lord.
We didn't realize that.
Okay, is this
No,
that will help you?
Para 6 does.
Para 6, yes, it does. Lord.
There are 6 years.
But he can't be allowed to blow hot.
Of an award and not before. We are unable to accept this differentiation. The principle is that a party shall not be allowed to blow hot and cold simultaneously. Long participation and acquiescence in the proceeding preclude such a party from contending that the proceedings were without jurisdiction. We are grateful for your Lordship's memory.
What does Russell on arbitration say?
It says, Lord. Para 7. Russell on arbitration explains the position. If the parties to the reference either agree beforehand to the method of appointment or afterwards acquiesce in the appointment made with full knowledge of all the circumstances, they will be precluded from objecting to such appointment as invalidating subsequent proceedings. Attending and taking part in the proceedings with full knowledge of the relevant fact will amount to such acquiescence. The judicial committee. The Judicial Committee in its decision in Chowdhury Murtaza Hussain versus Masumat Bibi Bechunisa observed, on the whole, therefore, the Lordship think that the appellant, having a clear knowledge of the circumstances on which he might have founded an objection to the arbitrators proceeding to make their awards, did submit to the arbitration going on, that he allowed the arbitrators to deal with the case as it stood before them, taking his chance of the decision being more or less favorable to himself, and that is too late for him, after the award has been made, and on the application to file the award, to insist on this objection to the filing of the award. Relying on the aforesaid observations, this court in N. Chelappan versus Secretary KSEB acted upon the principle that acquiescence defeated the right of the applicant at a later stage. In that case, the facts were similar. It was held by conduct that there was acquiescence. Even in a case where initial order was not passed by consent of the parties, a party by participation and acquiescence can preclude future challenges. In the grounds of appeal, no prejudice has been indicated by the appointment of the second arbitrator. This is very, very important. We are grateful to your Lordship. We just wanted to conclude by saying what is the prejudice they have to answer. And page 115 to conclude, Lords, para 27, the second compilation. It says thus, Lord, as a principle of law, the powers of the civil court being plenary in nature, the onus lies on the party who contends that it lacks jurisdiction. However, this does not take away the duty of the civil court to check its own jurisdiction, more so when a specialized forum has come into being as a creature of a statute. Of course, there may be certain exceptions when fundamental principles governing common law, including the ones pertaining to the principle of natural justice, stand violated. To deal with the said issue, one has to take into consideration the objective behind the enactment along with the provisions contained therein under, and then Dhulabai, which is section 9 CPC, my lords. Like I said, my lords, order 21 does not even find mention Lords, the reverse would have been prejudicial to them in my humble submission. If Lords, the learned commercial court would Lords cut across order 21 to adopt a different procedure, then perhaps they could have said that no, civil court only should. The entire order 21, Lords, the problems of a litigant begin in India after a decree. Lords, they have held so many times. This is the reverse case. He successfully stalls my execution and then comes and says that it should have been expedited under the Commercial Courts Act. So there is no prejudice, not it's the same learned district judge would have been designated as the learned commercial judge. Not in 2025, my award amount was 65.47 crores, not a single paisa paid. We are deeply obliged to you, Lord.
Payments have been released and not a single paisa is absolutely factually incorrect.
No.
My lords,
I filed an IA, you have not responded.
No, my lords.
So we are deciding a point of.
Very well.
Don't be
Right.
bothered about whether payment has been made or not.
Right. And my lords, the first point, my lords, where is the prejudice, my lords? 30 saying that I had stalled the proceedings. 34 and 37 does not mean we are stalling the proceedings. It's I'm entitled, my lords, as a judgment debtor, my lords.
34, 37.
Right, very well, my lordship.
Before the High Court.
Right.
That the additional district judge at so-and-so place, he is not the commercial court, designated commercial. And you have succeeded on this.
True, my lords.
That is stalling.
Yes, my lords. The
Stalling
thing,
execution. You pursue a remedy under 37, nobody stops. But today, please answer first 15.5.
my lords, I'll come to that, my lords.
No, first 15.
Very well, my lords. Your lordship may kindly come.
Start with 15.5.
Very well, my lords. Lordship may kindly look at 15. My lords, I've got other points, my lords. We have to come to 3 and 6. But I'll first answer your lordship straight away.
Up to 5.
Yes. My lords, come to 15, my lord. Let us see the whole 15 as a whole. And then, my lords, your lordship may kindly see 15.1. All suits and applications, including applications under the Arbitration and Conciliation Act, your lordship may mark that as well, relating to a commercial dispute of a specified value pending in a high court where a commercial division has been constituted, your lordship may kindly mark these words, shall be transferred to the commercial division. I'm coming down.
What is the heading of the chapter?
My lords, transfer of pending suits.
The suits would include execution.
My lord, that's what the all suits and applications, your lordship, it explains.
Justice, if you go by Justice Chirappa Reddy's
Right.
view, not only every section, you have to read the chapter headings also. So marginal note that, marginal note does not conform with the body, you can leave aside the marginal note. But the chapter heading is very important.
It talks about the Arbitration Act.
Suits.
Correct, my lord, but the provision specifically talks about the Arbitration Act. It very well clearly states that. My lord, your lordship may kindly mark the word shall. Your lordship got it, my lord, 15.
Shall be transferred.
Shall. Lord, it has got some meaning, kindly mark shall. Now again 2, my lord, section 15.2. All suits and applications, my lords, including applications under the Arbitration and Conciliation Act. Again, my lords, a reference to the Arbitration Act. Relating to a commercial dispute of a specified value pending in any civil court in any district or area in respect of which a commercial court has been constituted, again mark the words shall be transferred to the commercial court. So both the provisions talk about there being a shall. In other words, it's a mandatory provision. Now lordship may kindly come to 15.3, which is according to me an automatic provision. Now your lordship may kindly look at 15.3, where any suit or application, including an application under the Arbitration Conciliation Act, 3 times they use specifically the Act, Arbitration Act, and they use the word application. Relating to a commercial dispute of specified value shall stand transferred to the commercial division or commercial court under subsection 1 or subsection 2. The provisions of this Act shall apply to those procedures that were not complete at the time of transfer. Now, my lords, it is a automatic transfer here. There is no legislator, there is no, in fact, my lords, my most respectful submission is an interdiction of a court is also not required. Because, my lords, for the simple reason that it is an automatic transfer, my lords, I would like to place my, make good this, come to 15.5 minutes. I'm now coming to 15.5.
It is accepted.
Now 15.5 minutes. Now come to 15.5 minutes. That's the problem we are facing. 15.5, your lordship may kindly see, in the event that such our application is not transferred, that is any of the 3 things happen, despite the automatic transfer.
Automatic?
Yes.
It doesn't happen.
It does not happen. Then what happens? in the manner specified in subsection 1, subsection 2 or subsection 3, the commercial appellate division of the High Court may. Now your lordship may kindly mark the word may. My lords, here my lords, as far as the volition of the parties are concerned, the word may is used. Whereas in all the other three provisions, the word shall is used. Therefore, my lords, if two different words may and shall are used in the same provision, my lords, may should be read as may, shall should be read as shall.
Under 15.123.
Right.
Who transfers?
Now let's the A15.3 code transfers. It
Transfers
well, or it automatically gets transferred.
automatically. So it's the code that transfers.
Right.
It's an administrative function.
This may not be so, my lords,
It's an
because
administrative
my
function.
lords, but then the court has to decide the jurisdiction.
Shall,
Yes,
so all suits and applications shall stand transferred.
true.
It does not require the judicial order of the court.
My lords, it may be required. I will tell you, lords, why, my lords, because it talks about territorial transfer as for
Yes.
15.5.
If it is not transferred, there is a duty, there is a automatic transfer. If all these conditions under 15.1, 2 and 3 are fulfilled. Suppose
Right,
it is not transferred.
right.
And a person like you who thinks that yes, it should have been transferred, but why has the court not transferred it? So you make an application.
May.
You make an application.
I may make an application. My lords.
Wait. You are given the
Option.
enabling provision.
Right,
So it enables a party. A party feels that why should it be heard by the civil court? This is covered by the commercial courts act.
true,
So it should have been automatically transferred.
true.
But for some reason or other, it is not transferred. So this enabling provision gives you the
An entitlement.
authority to apply before the court.
It's an entitlement, my lords, but
Entitlement. Now this may means the court may hear the registry also why it has not transferred.
not necessarily.
Registry may give an explanation. That is why decision is left to the
No.
court.
Well, let us read the entire.
No. Please be. Entirety is this. What is the object? What is the object of 15.5?
My lords, I'll straight away answer.
By a slip of the administration, any suit, any application which could have automatically gone to the commercial court under 1, 2 or 3
Three.
has not gone. But it may be so that the registry may have some objection that for this reason it should not go.
No, it's not.
So when you make an application, the court applies its mind. Court may accept your version that all
may not.
boxes are ticked in my favor. It should go. It could also happen that the registry points out something that it is for this reason we have not sent.
My
So
lords,
therefore, even if the registry raises a justified objection, the statute will say that shall, the court shall. That is why it's may.
my lord, that's a, my
That's why it's
my lords, may is for a different reason. The may is different because 15.5 talks about territorial jurisdiction.
Why didn't you file an application? Tell us.
My lords, the fact is,
Why didn't you file it?
My lords,
Automatically it did not go.
my lords, answering your lordship's point, my lords, let's look at 15.5, my lords, let me complete that argument, my lords. I'll answer that point, my lords, because that could be important.
Please.
Your lordship may kindly look at 5, my lords.
Yes.
I will read from, well, shall I read that provision again, my lord?
Entire-
In its entirety, just 15.5, my lord, please bear with me. In the event that such suit or application is not transferred in the manner specified in subsection 1, subsection 2 or subsection 3, the commercial appellate division of the High Court may, on the application of any of the parties to the suit, withdraw such suit or application from the court before which it is pending and transfer the same for trial or disposal to the commercial division or commercial court as the case may be, having territorial jurisdiction over such suit, and such order of transfer shall be binding, final and binding. Now, my lords, as far as this provision is concerned, it comes into application only when there is when there is a dispute with regard to the territorial jurisdiction, not with regard to the subject matter jurisdiction, lords. In which case, it's not merely an administrative order because 15.5 requires a judicial determination as to whether
15.5 leaves it open about the subject matter. If you see, it will be transferred to the court having territorial jurisdiction.
yes, therefore only territorial jurisdiction would, therefore judicial determination is required. Subject right jurisdiction, that's why may is
So
used.
therefore, let us assume, as in this present case, the concerned judge did not have the jurisdiction because he was not the designated.
To start with.
Right. Now, if you had made an application under 15.5,
Not, I have not made.
if you had,
Right.
listen,
Right.
we don't waste words.
Right. Right.
If you had made an application, that this is a case which is covered by 1, 2 and 3, and therefore registry should have automatically transferred it. It has not been transferred. So please transfer. Mr. Gupta raises an objection that no, it should not be transferred for XYZ reason. Then you are asserting that it should be transferred. He is asserting it should not be transferred. Leaving aside the registry's view. Now, if the court is in your favor, right? There are two designated commercial courts.
Right.
So this matter cannot go to both courts.
One of the courts.
So this is that. Last portion is that. To which court between the two it will go is determined by the law.
No, that may be in the fact situation of this case. But when the lordship is laying down the law,
And transfer the same for trial or disposal to the commercial division or commercial court as the case may be, having territorial jurisdiction over such suit. What you say that it
then my lords, if that is the case, my lords, then my lords, 15, 1, 2, 3 becomes OTOs then.
Of course not.
My lords, it does, my
Of
lords.
course not. Of course not.
My lords, but
1, 2, 3, you say that it is covered. He comes and says it is not covered. Now take the converse case. The court holds in his favor that yes, Mr. Gupta is right. It is not covered by 1, 2 and 3. What happens? Court may, therefore court will refuse your prayer and court will say that the court before which the proceedings are pending, that court will proceed.
my lords, then my lords, if the three sections, if my lords at the three different stages of 1, 2 and 3, my lords, one misses, then 15.5 should not be a corrective exercise that you go back to 15.3.
Come 15.5, we have got your answer.
So,
The other points.
right. Lordship may kindly come to section 3 and come. My lords, and there is no waiver in 15.5 also, my lords. Ultimately, my lords, as far as the jurisdiction of 15.5, my lords, is concerned, then, my lords, probably, my lords, in a case, apart from, not in this case, my lords, generally, then in every case where 1, 2, 3 fails, if the remedy under 15.5 is not exercised, then 1, 2, 3 need not be followed at all. My lords, in such cases, my lords, with great respect to your lordship, if 1, 2, 3 fails, five, my lords, would not be a would not be a saving provision to cover up 1, 2 and 3 failure. That's my short submission.
Look, sir, when this act came,
Right.
it came with an object that commercial dispute should be settled. Right?
Right.
So 15, 1, 2, 3, do they involve any judicial function of the court?
With great respect
As
to
we
you.
read it, shall. Arbitration. Does it involve any judicial function?
My lords, ultimately,
Without,
my respectful
there's
submission is
nothing about judicial. It's left to the administrative side of the court. Now, if the court, a genuine case is not transferred and a party is seeking early disposal, what will he do? He is given the remedy by 15. You can approach the court. Look here, sir. Your officers are not doing it. Wait. He raises an objection. Either way it can go. This is the judicial function. And territorial jurisdiction would mean if there are multiple commercial courts, the court will have to decide which court it will be.
Lords, there is no prohibition of raising it at a later stage, my lords, apart from that. Because, my lords, if,
There is
my
no
lords,
provision, but today everything depends on the facts and circumstances.
no, my lord, definitely true.
Right?
My lords, because what happens is, my lord,
When you have been given the
option to,
which you don't do it.
my lords,
And then after
they could have also raised it. my
But
lord.
what is the, they have not raised it, very good. What prevented you from doing it?
No, it was not raised.
Say, what is,
That
the
is,
court had
stars at my face, it has not been
So
raised.
therefore, Justice Sundaresh's judgment is on actus curiae nemanim gravavi.
My lord, that's a different.
It was the court's duty.
My lord, but that, my lord,
It has not done it. Why should a party suffer?
my lord, but then, my lord, we can't.
And why should the party suffer? Because here it's going to an additional district judge level officer. It's not going to a munsif.
My lords, the whole provision, my lords, if 15 becomes a purely administrative act, my lords,
Which one?
the whole of section 14, my lords, if there is no judicial
But
determination,
not 15.5. 15.5 is judicial.
15.5 is judicial, my lords. In which case, my lords, the option is still given to me, my lords, to raise it in for in.
You did
I
not.
did not, but then 4, my lords, the waiver would not arise.
What stage?
My lord, this.
You can even raise it before the Supreme Court.
My lords, no, my lords, in fact, in the High Court, it was argued by consent.
Assume
Right.
that the execution case continues before the additional district judge civil court, not the commercial court.
Right.
Right? Orders are passed. And for the first time before the Supreme Court also you can raise this point.
No, but not in the first time, my lord. No, it's not.
It's a question of law. Chaman Paswan says you can raise it at any point, even in collateral proceedings.
My lords, I'm not going to that extent for this case.
We
Because
respect our precedents, definitely, but having regard to this 15.5, which is a special provision,
My lords,
we have to, change our.
my lords, in which case, my lords, it will not be an omnibus provision in the sense, my lord, this is determination as far as this is concerned. Because as far as this was not raised here for the first time. High Court by consent of parties, this point was raised and it was argued. So, my lords, by consent of parties, I take your lordship to the High Court judgment that this point was raised on understanding that, my lords, once the edifice goes, then everything falls. Ultimately, no prejudice because instead of this court, they could get this, they can move the other court, my lords. There is no prohibition as such. And now, my lords, since, my lords, your lordship, since the issue has been raised with regard to 15.5, whether it is administrative or judicial, my lords, apart from that fact, my lords, that probably it may, to lay down, my lords, a law with the entire provision, my lords, because this was not argued in the High Court as well. This point, whether it's a judicial determination, it was an administrative determination, was not raised, but it was only argued on the threshold of 15.3, 10, 6 and 3. Therefore, my lords, your lordship may kindly look at the exclusivity of this act. The exclusivity of this act, my lords, is contained.
There is no point in remanding the matter to the High Court at this
No, I'm just suggesting.
Right.
My lords, I'm just.
Point may not have been raised. Well, you will answer.
Since my lords,
Now that it is raised before us.
No, we are answering.
Point of law.
Yes, yes, my lords. Now, your lordship may kindly look at section 3, my lords.
Yes, section 3.
Constitution of Commercial Courts. Lordship. Your lordship may kindly mark the words. The state government may, after consultation with the concerned High Court by notification, constitute such number of commercial courts at district level as it may deem necessary for the purpose of exercising the jurisdiction and powers conferred on those courts under this act. Therefore, my lords, there is an exclusivity which has been created in section 3 that for exercising powers under this act, these courts have been constituted. So therefore, that actually, my lord, debars the exclusion of another court, which, my lords, could be also found from section 21. Lordship may kindly look at section 21, my lords. Act to have overriding effect. The scheme is exclusivity, both at the stage of, my lords, determination and even at the stage of execution. Lordship may kindly come to 21, my lords. Act to have overriding effect. Save as otherwise provided, the provisions of this act shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force or any instrument having effect by virtue of any law for the time being in force other than this act. So therefore, 3, my lords, read with 21 creates an exclusivity of courts which clearly lays down that there is an embargo on other courts to try these cases both at the trial determination, judicial determination, or even at the stage of execution. Now, your lordship may read it with 6. My lords, your lordship may read it 321 with 6. Jurisdiction of commercial court. The commercial court shall, again, my lords, your lordship may kindly see the word shall is used. The commercial court shall have jurisdiction to try all suits and applications. The lordship may look at the mark the word application because 36 of the Arbitration Act talks about applications. 36 very clearly says it's an application. The commercial court shall have jurisdiction to try all suits and applications relating to a commercial dispute of a specified value arising out of the entire territory of the state, so and so, so and so. Now, my lords, when section 6, my lords, it is a stage, my lords, each provision, my lords, has to be read, my lords, as one following the other. If, my lords, that jurisdiction has to be decided, subject matter jurisdiction has to be decided at section 6, my lords, at the section 6 level, that is the very exercise of jurisdiction at 6, my lords, then coming to, my lords, 15.5 to knock away 6, my lords, would be my great submission.
Yes, next matter first at 2 o'clock.
Very good.
Because we had stopped the council from arguing yesterday because of another fixed matter. After that, we will come back to you.
Very good.
I mentioned, Lord, item 8, your Lord.
For R2 and R3, Manoj.
Karnataka matter, your lordships had fixed at 12. There is a letter from the state government, they have filed additional documents and affidavit today morning and they wanted an adjournment also. So if your lordship can fix it.
Back to the petitioner, the state government, that we are
I think that will not be heard by this bench.
Oh.
We'll hear it, I'll hear it with the.
Very well.
It's not a pattern matter.
Then
I think it's not a pattern matter.
No.
No.
Not a pattern matter, madam. After vacation, we will.
Very well. Not just one procedural issue. Not some procedural issue. Service had to be not by paper publication.
That has not been done.
Item 8 will stand over.
No, paper publication must be done in all SLPs, my lord.
Yes.
But the registry thought it's only in one SLP, so we were not given that. Would your lordship consider saying it?
If time permits, we will call on item number 8 at the end of the board.
Very well.
We'll wait.
Because we need to come back and start with the other matters.
My lords, I apologize in that item 31. I was in my legs in another court. My lords, that's that contempt matter.
We have passed it.
Yeah, my lords have passed it over. My lords, my worry is that I have a prefixed matter.
We are keeping it beyond the partial working days. We are keeping it as not.
My lords, whichever way, but my lords, I sincerely apologize. I was on my legs. In fact, I instructed my colleague, she had to go ahead with the matter, but she hesitated.
Also, it was called.
My lords, I was on my legs. That's why. The other day,
We'll hear it.
so my lords were
Number 8 would be after the partial court working days. Not to be.
grateful, my lords. Much obliged.
But please inform the other side.
My lords, I will do that. I'll do that. No, 31. 31. My lords, I will inform the other side. I'll have my colleague.
But this order will be transcribed only upon hearing her because she had raised vehement objection on Tuesday, saying that because of subsequent developments, the court should not decide the issue. This was the submission.
My lords, yes, she wanted to show an order which she had shown the last time. That I will argue.
Provided she agrees, we are.
Yes, I'll tell her.
With my lord's permission, may I mention my item 28, my lords had pronounced the order in that HSBC matter. We wanted a small clarification, my lords. My lords, originally their extension was only till 31st December. On 12th January, when my lords had extended it till 30th June, my lords had said that the issue of rent will be determined. So I just wanted to check.
Left it to the court.
My lords, even for this 5-month period, because they've not paid us anything.
They have not paid, but we have, while refusing their prayer for extension of time to vacate,
My lords.
we have also left it open for the query court as directed by the High Court. They will decide what will be.
My lords. My
We have
lords,
not taken upon ourselves.
may I show this order once? 12th January. My lords.
I think that we have not,
No, not at all, my lords.
With
we
my
are
lord.
not going to burden ourselves with this.
Indeed.
We felt that everything should be going back to the challenge.
Because they mentioned
If I have heard your lordships correctly, your lordship would be taking up item 8 at the end of the board.
If at all time permits,
Yes,
we will fix a date
yes.
by calling the matter at the end of.
my lord, item 31 was mentioned.
One was mentioned at
Yes.
1 o'clock.
I'm going 31 for petitioner, my
My lords, I am requesting that a fixed date be given. My lords, this matter has been pending for a long time and several adjournments have been sought by the petitioner already.
Lordship 801, I'm really sorry to inconvenience your lordship. There was some unmuting problem in the morning. I was online. There is a date of September given because your lordship, I was not there. I'm really requesting for an early date. There is a stay operating against some for
For disruption, the result would have been the same. September.
your lordship, there is a stay against us. We've taken monies from people.
Possible, yes.
Obliged.
It's from 35.11.
Lord, yesterday, my lord, your lordships had directed us to place that advertisement.
Advertisement.
Clearer copy of the ad.
Calculated document, है ना?
एक कौन सी दे देना?
Indian Express.
Yeah, expense. On the iPad, it is little more clearer, my lord. Can I hand it off? I just want to see it from the iPad. My lord, I was now on the other matter, my lord, which is my lord Yashminara. That is not petition 557. It's serial number 1 in the state's my lord chart.
Yes.
The copies of that. Lord, may I hand over a chart?
So of this chart,
First, my lord, first item 1.
item number 1. Yasminara Khatun.
Yes, my lord. I beg to appear, my lords, for petitioner number 4 and 15. 4 and 15, my lord.
4 and 15.
4 is teaching. 15,
Rajkumar.
yes, my lord. 15 is non-teaching.
4 is Rajkumar. Rajkumar is at page 2 and 15 is at page.
Which page? I don't think it is in the state's chart, my lord.
Why?
Because non-teaching staff, my lord.
Non-teaching staff.
Yes.
You have a separate compilation for non-teaching staff like this.
It's petitioner number 15.
It's not there. Not there. Then start with this.
Yeah, my lord, yes, my lord. Now, if your lordships have my note, my lord, similarly to other matters, I prepared that note. Have you handed it over? It's given. But just have this chart, my lord. Now, my lords, the first one
in the just one minute.
Sorry.
In the chart, my lord, if your lordship would see, there are few. Just for example, in serial number 1, there are 2 persons, Rajkumar Bagh And
He is
then,
the teaching staff.
and then second name is Saifuddin, Sheikh Saifuddin.
That we are not.
You are appearing for Saifuddin?
No.
So then,
Very well, let us complete it.
So, 15. Yes. Sorry, Shaifuddin is 15.
Yes.
Correct, not. He is non-teaching. 15 is non-teaching. Is Saifuddin? 15 is 15. Yes, madam. 15 is Saifuddin. Okay. Right.
So this Saifuddin is which page of your chart?
my lord, the name is mentioned because they
Chart. Right, yes. Name of the non-staff provided in the petitioner's affidavit, that's Saifuddin. When will you start with Rajkumar?
Yes, my lord. Now, my lords, if your lordships have my note my lord, of 3 pages, if your lordship just have that, my lords will have all the relevant documents.
Yes.
Now, my lords, my appointment, my lords, is in January 2015 or to January 2016, my lord. Yes. That your lordships will get, my lord. In note 1. Now, my lords, the real problem, what the state is saying, is that, my lord, the tenure of the managing committee had expired and an ad hoc committee was functioning, and therefore these appointments, my lord, could not have been made. That seems to be the main, my lord, ground as far as these two persons are concerned. And, my lords, our respectful answer to that, my lord, are 2 things. My lord, this matter was pending in the High Court, and the High Court had constituted an ad hoc committee. That lordships will find that order, my lord, at page 184, at page 185, and these writ petitions are still pending consideration. Yes. Kindly have a look at, my lords, 186.
Yesterday you placed that order.
No, my lord, that is in some other, that is
Some other matter.
yes, my lord. Here, there your lordships will recall the High Court had said it has become defunct. It will, the existing committee will continue.
The page 186 of which document?
Now, this affidavit in this matter, my lord, which we have filed.
Today you have filed.
No, my lord, that is along with.
One is.
Just take it out. Yes, my lord. This matter was not. It's writ petition 557. There's separate affidavit, my lord.
In compliance with
1911-25. Yeah. Should have taken it out, no? Just hand it over, So I handed over my copy. Doesn't matter actually. I have it. To save time. It's affidavit in compliance. Yes, madam. That's the one. Lordships have an elephantine memory, my lord, because the page numbers are the same, lord, 180 in the other matter also, my lord, where that order was there. Lord, lordships will turn to 185. Order starts from page 184.
Just second copy is not there.
Lord, may I hand over my copy, my lord, to Justice Mass? I'm sorry, my lord, may have been marked. It's okay.
So where is this ad hoc arrangement?
Yes, my lord, kindly see, my lord, 185 bottom. We make it clear the said arrangement will continue till the disposal of the appeal, as we feel so long as the dispute relating to the constitution, reconstitution managing committee, and or the dispute which is involved in it is not finally decided, some independent officer must be there in the said institution to draw the government's aid from the government and disperse the same to the teaching staff and non-teaching staff. We also feel that some ad hoc arrangement should also be made for managing the day-to-day administration of the said institution until the appeal is finally decided. As such, we constitute an ad hoc managing committee with the following members for the running of the day-to-day administration of the institution till the disposal of the appeal. It is made clear that all the decision-related expenses which are required, so and so. Then, my lords,
It is very clear, expenditure only.
but then now kindly see the
Expenditure only, take money. Day-to-day function.
all the decisions relating to
There is that this DDO appointed,
correct, my lord.
right? So instead of the DDO, the ad hoc committee is being appointed for day-to-day functioning of the school
Yes, my lord.
and to manage the expenses.
Yes, my lord. Now kindly see also the next order, my lord.
The same ad hoc arrangement is continuing.
Yes, my lord. Now kindly see, my lord.
Decided.
After admitting the appeal, we made an ad hoc arrangement for running the administration of the said institution till the disposal of the appeal. We are informed that ad hoc arrangement
was made earlier.
Yes, my lord.
Will continue.
Will continue.
Right?
Yes, my lord.
None of these orders say that you have the
My lord,
ability of going forward with the process of appointment.
my lord, ad hoc, my lord's committee, my lord, is included. My lord, we just want to rely upon subject to your lordship's, my lord, consideration. The rules, my lord, which have been framed, just 2D, where?
Page 16.
My lord, in the rejoinder, we have, my lord, annexed, my lord, the West Bengal, the rules of management of recognized non-governmental madrasa. This is, my lord, 2002, which says, my lord, I'll read it and I'll place this also. It's there in the rejoinder as well. That, my lord, the madrasa committee of the madrasa or any other authority empowered to make appointment to the post which such employee for the time being holds, or where such managing the ad hoc committee, as the case may be, appointed to manage the affairs of the madrasa. So in our respectful submission.
Urge the court.
Yes, my lord.
Say that this would be the ad hoc committee contemplated by that rule.
Lord, I am not party, my lord, to these proceedings, my lord. Just my kindly.
Advantage of this, when the
Yes, my-
managing committee
Yes, my lord.
itself does not pray for that relief.
My lord, they have appointed.
The bottom is absolutely clear.
My lord,
Day-to-day functioning, what is day-to-day functioning? Incurring of expenditure.
my lord, that may be one way of looking at it, my lord.
There cannot be a second way of looking
My lord, but day-to-day
It
administration,
does not say anything else, Mr. Kamath.
my lord, but day-to-day administration would include, my lord, making appointments, my lord. My lord, in our understanding, my lord.
It is made clear. It is made clear what is the contours within which you are to function. It is made clear. All the decisions relating to expenses which are required for running the day-to-day administration will be taken by the SEC until the.
Yes, my lord. But
the other powers
it is clarified, my lord, in 187, 188 also.
What decision you are showing?
My lord, sir, we were showing, my lord, just two things. One is this rule, my lord. That is, my lord, 2D1.
Rule 2.
2D1, my lord.
1.
Yes, my lord. Which says that the managing committee will include, my lord.
Found that page.
My lord, this is found at page 16 of the main rejoinder. My lord. I'll give a copy, my lord. Yes, my lord.
We'll get it photocopied here.
Yes, my lord.
Not too thick a rule. No, not required. Just photocopy.
And second, my lords, your lordship's decision in my lord's TMA Pi, my lord, there's one paragraph. If it meets your lordship's, my lord, approval, may I place that, my lord?
What is the 2002 volume 8 or something like that?
Yes, my lord. It's 2002, volume 8, my lord.
Volume 8.
Page 481.
481 para.
My lord's paragraph, my lord. 450. The answer to question 5, my lord.
450.
5C. I'll just read it.
What is the answer?
My lord, 5C. Whether the statutory provision which regulate the facets of administration, like control over educational agencies, control over governing bodies, conditions of affiliation, including recognition, withdrawal thereof, and appointment of staff, employees, teachers, and principal, including the service conditions and regulations, would interfere with the right of administration of minorities. So far as the statutory provisions regulating the facets of administration are concerned, in case of an unaided minority educational institution, regulatory measure of control should be minimal, and the conditions of recognition as well as conditions of affiliation to a university or board have to be complied with. But in the matter of day-to-day management, this is what, my lord, we are placing for your lordship's consideration, like appointment of staff, teaching and non-teaching and administrative control over them. The management should have the freedom and there should not be any external controlling agency. Now, this is only to share.
Answer once again.
Yes, my lord.
And when we say you stop, please stop.
Yes, my lord.
Read it.
I'll read it further, my lord. However, a rational procedure for selection.
No, just the answer you just now read out.
Yes, my lord. So far as the statutory provisions regulating the facets of administration are concerned, in case of an unaided minority, this is an aided, my lord. There's no doubt.
This whatever you are saying.
Yes, my lord.
Is concerning unaided.
Yes, my lord. But I am not.
How does it apply here?
No, my lord. I am saying.
How does it apply here?
No, my lord. I am not placing reliance, my lord, in the context of. My lord, I am saying day-to-day administration. It is well settled, my lord.
Help you. It is in respect of unaided institutions. These are purely aided institutions.
No doubt about it, my lord. But what I am respectfully submitting, my lord, day-to-day administration will include, my lord, things such as appointment, etc.
I cannot infer from this that day-to-day would include.
But there is nothing excluded, my lord. Yes.
This is answering a specific question which was posed before the 11-judge bench.
My lord, as far as this order.
Minority, we will extend it to aided minority institutions.
Correct, my lord. I am only placing reliance on page 185, 186, my lord. That there is nothing in the order which says, my lord, that the appointments were restricted. If your lordship sees that order, my lord, and the clarification which is issued on 187, 188, my lord.
We will consider. Yes.
Yes, my lord. Lord,
both the persons are in the same madrasa?
Yes. Same madrasa, my lord. Same madrasa.
Kumar and Saifuddin.
Yes, my lord.
So, we can deal with one order.
And my lord, all the, my lord, as far as educational qualification is concerned, advertisement, my lord's written test, all those parameters are fulfilled. It's nobody's case, my lord. But at the end of this, my lord, submission, my lord, I just want to place two things, my lord. Your lordships are aware, my lord, since the judgment of the learned single judge, my lord, before the Calcutta High Court, there was when the matter was pending in appeal, my lord, there was an interim order which said, my lord, the appointments would continue. When the matter was pending before your lordships, my lord, there were about 5 orders, and I'll just give those orders, my lord. 10th of May 2016, 17th of May 2018, 4th of December, where I was a party, my lord, 4th of December 2018, and 13th of June 2019, where, my lords, the court repeatedly said, Lord, these people are in service. Please give them their salaries. Today, my lords, just lift.
We have read into those orders.
Yes, my lord.
While disposing of the contempt petitions, that those who are in service would mean those who are valid.
Correct, my lord.
Otherwise,
today your lordships are deciding.
Spend
yes, my lord.
For somebody who is not entering service through the main door, but through the back door. But that public money has to be spent.
My lords, kindly see from a slightly different perspective, my lord.
Right.
My lord, this is not a case, my lord, where people, especially my clients, my lord, have come in through the back door. My lords, with the greatest of respect, my lord, there was an advertisement.
It's a committee report that you are not entitled to continue in service.
Correct, my lord.
What is the reason given?
This, my lord, ad hoc committee.
Or for B.
Ad hoc committee, my lord. Yes, my lord.
Are not duly and validly appointed. That is the date.
Now, my lords.
Otherwise, in terms of our order, you would continue in service.
My lord, if your lordship sees the facts of this case, my lord, the only thing which has been put against.
If you don't satisfy our conscience that you have a right to continue in service.
I bow down, my lord.
Do you have a better right to get a salary for the period you have put in service? You also know how you entered the service.
No, that is why I just want.
Door or through the back door.
No, that's why, especially these, my lord, all the clients which I appear for.
Yes.
There is no question in our respectful submission of a back door, my lord. My lord, open, my lord's selection. Advertisements were, and for no fault of us, my lord. If the ad hoc committee could not, now your lordships are of the view, my lord, and maybe, my lord, rightly so. Your lordships are today of the view that an ad hoc committee could not have made appointments in terms of, my lord, the order of the High Court. And this was not an issue, my lord, till today, till the, my lord, the committee appointed by your lordships decided this. Then can the, my lord's candidates be penalized? Is a question which I asked myself, my lord. Lordships may consider this, my lord, exercising your lordship's powers under 142, because, my lord, Uma Devi is not an absolute principle. And similarly, Dayan is not an absolute principle. Your lordships will have to, my lord, have some harmonizing principle in between, where, my lord, lordships may make categories, where, my lord, for no fault of the students, I can understand, my lord, that
somebody's cousin, somebody's, my lord, relative has come in through the back door, your lordships may not protect such people. But people, my lord, who are unaware and have, my lord, bona fide, my lord, applied, seeing the advertisement, they, my lords, after 10 years, 7, 8 years, 9 years working in that institution, my lord, to be told that, look here, the original committee, ad hoc committee did not have any right to appoint you. That may be a little harsh, my lord. I appeal to your lordship's conscience, my lord, to exercise, my lord, your lordship's jurisdiction under 142 and protect them.
Next.
Just.
Malas, I'm appearing writ petition 800 of 2024, Malas. I have filed, Malas, 2 affidavits.
What is the name of your client?
There are 43 petitioners before this court, out of which I have taken 2.
Out of the 10, where does
In the
your
list
client
given
stand?
by the state, there are 1 person is there, serial number 8.
Serial number 8.
Yes.
Serial number 8 is
Page number 17, Malas.
page number 70.
Yes.
Page number 16. Rajun
Kasmina, yes.
Huh?
She is a Malas, non-teaching staff
Achha.
appointed in Depun Madrasa, which is in Murshidabad.
This what you have to say about her?
Malas, Malas, I prepared a list of dates and I can give it to you, hand over to your lordship. Court Master. Malas, at the outset, Malas, the report against this petitioner is completely non-application of mine, Malas. Malas, she was appointed in the post of Malas clerk, Group C post, by the managing committee of the concerned madrasa. In the report, if you lordship kindly see, page 17, right hand corner, Malas, 8, lordship got page 17.
Where is the advertisement? Start from the advertisement.
Advertisement was, Malas, it is the advertisement was not following the rules, but there was an advertisement. It was not published in
Or what is the
Lordship,
mark of this advertisement?
See,
Mr. Roy?
Malas, I just
It's
go on.
only a show
It's not so.
advertisement. You just now said it was not published in the newspaper, but it was published.
But it was published
Where?
in a conspicuous
Conspicuous place of the locality,
locality.
right?
Yes. And what are the places,
Only
Malas?
the people of the locality
Yes.
who have the right to participate, or the entire population of West Bengal have the right to participate.
Malas,
Tell us.
that's true, Malas. That's
Then-
true. So the advertisement,
Therefore, is Article 16 maintained?
Malas, Lordship, kindly, I'm sorry, so far that this part is concerned, Malas, because this petitioner has no fault. She saw the advertisement.
You are saying this. No
She-
fault. We are
She
saying that.
saw the advertisement, pursuant to the advertisement, she is qualified, she's qualification is not in dispute, Malas. There is a vacancy in the school, that is not in dispute. Malas, there was a, Malas, the sanction granted by the DI of school, that is not in dispute. Only the problem is advertisement. Malas, I must confess over this part is concerned, Malas. And it was, page 40 is the advertisement, Lordship, and I will look at it.
So, looking at that advertisement,
Malas,
it is not there as per the rule,
yes, Malas,
and you are conceding to this effect.
Malas.
It was a very difficult hurdle to cross.
Malas, and all this appointment was made, Malas, with great respect, Malas, after the order of the High Court, which was, Malas, in the earlier judgment. Malas, Lordship may not get annoyed to that. May not get annoyed to that also. All the
I distinctly remember what happened in courtroom number 14.
yes, I argued that point, Malas. Yes, I argued the point. Para 64, I argued this before your Lordship, Malas.
You have some responsibilities as a designated senior.
Yes, Malas.
Yes.
Therefore,
The client, but
Yes.
also to the court.
Malas, this petitioner, Malas, apart from the discrepancy in the advertisement, Malas, she fulfilled all the requirements.
We are recording that.
And report submitted by the Malas, the committee, Malas, her single documents has not been taken care of, Malas. But you can see the chart submitted by the state, Malas, page 17.
The managing committee.
Yes, ma'am.
Not appear before the day committee and produce this document.
They produced, Malas. Logically, they have produced.
If they are produced, come to 17.
17 years, Malas. And what?
See the right hand side column.
Yes, extreme right hand side column, the petitioner came appointed as a group D post.
Yes.
And she didn't appoint for the group D. She was appointed for the group C post. And there's the documents on record. Lordship, kindly see my affidavit. Lordship, kindly see my affidavit.
What was the post for which you applied?
Clerical post. Where the requisite qualification was class 10.
Let us assume that it is group C. Come to page 18.
Page 18, yes. Chart.
Yes.
I'm coming to that one. Yes, Malas. The qualification is not in this.
You said that you were appointed by a resolution of 18 December 2015.
Yes, Malas.
No such resolution exists in the official records.
Malas,
it is for the managing committee to produce the records before the committee.
Yes,
and so that you don't have the resolution.
I have the copy of the resolution, Malas.
Managing committees appear.
Malas, with great respect, what happens before the committee, Malas, you can see. They are not allowed to enter into the individual cases are not been taken into considerations. They are not allowed to enter into the Malas, the interview room. Nothing, Malas. It was outside. They asked to submit the documents. They handed over the documents. Whether managing committee was there or not, they are not aware of it. Malas, I produced all the documents. It's not the manufactured documents. It's the original records, which is there in the writ petition also, which was the earlier contempt petition also. It's not the first time I'm producing with my writ petition, Malas. With great respect, Malas.
Your name was recommended by the selection committee.
Selection committee. Yes, Malas.
Who are the members of the selection committee?
Malas, the constituted managing committee. Malas, there is no nominee from the government. There is no nominee from the government.
And that is the second fault. First, there is no advertisement. Second, in the selection committee, there is no government nominee.
Malas, it was not there. Malas, I was asked, Malas, I applied, I was asked to appear before the committee. I appeared before the committee and they found I am the suitable among the so many candidates. Malas, I was selected and I was allowed to join in the post. Malas, I didn't play any frauds over the selection process is concerned, Malas. The candidates, Malas, Malas, one more submission.
Mr. Rai, you know where you stand.
Malas, I know where I stand, Malas.
Next, you know.
I just
your next candidate.
One more submission, Malas. Malas, Lordship, can you see? Today also this lady is working in this school. Today, Malas, I am taking with great responsibility. Today she is working in the school.
Turns on it.
Malas.
Nothing turns on it. There is something called equality in the matter of public employment.
Yes, Malas.
How do you achieve that equality?
Malas, the problem created by the high
problem created by the High Court.
Yes.
By first declaring it ultra vires.
Yes, Malas.
Second time division bench by upholding the single bench order.
Yes, Malas.
Third time Supreme Court by allowing appointments to happen
within interim period.
They are all responsible.
No.
Russia is responsible.
I don't
Nobody
say,
else.
I cannot say so. It amounts to contempt. Malas. I can't say so, Malas.
Come on, next candidate.
Malas, Lordship, can you see, Lordship? Lordship, while contempt, Lordship kindly consider, while Lordship was deciding the contempt petition, Lordship kindly took the aid of Article 142 of the Constitution of India,
yes,
and constituted a committee to determine, to take the decision.
We did not want the state government,
yes, Balas,
to back the committee with its own officers. We thought that a neutral committee constituted by the Supreme Court could put in peer review.
Malas, yes,
right?
Yes. It has not happened, Malas. With great respect, Malas. There was
everyone will remain aggrieved if the report is advertised.
No, Malas, it's not like that. Malas,
not happened.
I am told by just one representative was from the Madrasa board.
Mr. Rai, come to your next candidate.
Next candidate.
Next candidate, because we are short on time.
Next candidate stands in the same footing.
Same footing.
Same footing. That is not in the chart.
Very well. What is the name?
Yes. His name is Malas. He's the assistant teacher's Malas.
So he's a teaching staff.
Assistant teacher.
Very well. What is his name?
His name is Malas. Shikha Khatun Malas. SHIKHA KHATUN. SHIKHA Shikha Khatun.
Assistant teacher in
assistant teachers in Bengali Malas.
Assistant teacher in Bengali.
Yes, Malas.
Number 7,
there was a vacancy.
number 7 in the chart.
Number 7 in the
She's
chart.
there. She's there. I missed it, Malas. I'm sorry for that. Thank you. Sorry, Malas, I missed the chart. Yes, Malas 800. I'm sorry, Malas. Extremely sorry, Malas.
Not even take up your word.
Where's the stock pattern? Creation of additional posts, and whether on the date this so-called advertisement in the locality was made, there was a vacancy. First,
See that. Just a minute, Malas.
Yeah, I remember.
एक एडवर्टाइजमेंट पर इंडेक्स पे देख
There was a whole bunch of application solutions for it. Space principles. We had filed the counter. This was second.
Malas, it is not on record, Malas, the advertisement. It was the local advertisement, Malas.
next candidate,
Yeah, no, I'm wrong.
next candidate.
My candidate's name is serial number 10 in the list.
Serial number 10.
He is a part of WP 105, that is 35.41.
Don't mention 35 point so and so. He'll go by this chart.
Kindly,
Serial number 10.
if your lordship kindly permits me to address your lordship, essentially, on the findings of the, because one thing your lordship needs to be, kindly pardons me, the committee examined the cases of 497 persons who were before the committee, who had submitted various representations and reports. Now, my lord, or my lord, they had claimed, staked a claim. Now, my lord, the committee unfortunately did not find even one candidate, according to the committee, to have fulfilled the, my lord, requirements as per the committee. Now, my lord, please pardon me again.
So even if 197 did not fulfill,
Yes.
the committee had to say that.
No, I mean, I am saying only even one could have. What I am
What do you mean by
what I am essentially on is,
think everything is so suspicious?
it is not, with respect, no.
Mr. Bhattacharya, whether committee found anyone qualified or not is decided.
The committee has solicited reports,
Please.
reports behind our back.
Mr.
reports-
Bhattacharya, answer the questions. 10 questions or 7 questions were framed.
I am trying.
How have you answered? Let us know.
I am trying.
Please come to serial number 10, page number 21. If you have your own list, you can provide it.
I am essentially on serial.
Has not given you hearing. For the moment, we will accept you.
The committee has given me a hearing, relying on documents which were not disclosed to me.
Very well. We will give you the opportunity.
The committee has
We take the judgment of this court in LK Ratna. We will allow a fair appeal.
By an unfair trial.
After an unfair trial. Yes.
Today,
It's a question of giving you opportunity of hearing. So we are giving you the opportunity. Don't go here and there.
3rd March 2016 is the base of this selection. All my candidates, whoever is a part of the petition, including the person at 10.
We are not considering all the candidates.
10.
One
Serial number 10. Serial number 10 is a candidate.
Serial number 10 been found to be disqualified. Tell us.
Please see.
He was,
There was an advertisement here, 2 newspapers.
he is a assistant teacher.
Yes.
Very well. Teacher in which group?
Yes.
Assistant teacher in?
Just I'll give you. Physics.
Assistant teacher in
Physics.
science group.
Science group.
Science group. Very well. Where is the staff pattern? First was.
Kindly comes to my application, which I have filed. There is a.
What is the number of the application? Can you please?
It is filed in connection with that affidavit. It's a. I'll give you a lot. No, this affidavit is IA. 4-month connection. Azad Rahman. देखिए इसमें है ही हम
Yes.
Now please see page 80. Page 80 is the advertisement. 12/7/19. Now, one thing needs to be told to your lordship is definitely aware, but still, for the sake of repetition, I am respectfully submitting that there was no requirement in the rules to seek any permission for the publication of any advertisement.
Have we asked you?
This is the rule.
Have we asked?
No, your lordship has not.
You have not answered our question. Where is the staff pattern?
Please see, I am showing you a lot.
Staff pattern.
Then the next.
This is not the staff pattern, Mr. Bhattacharya.
Please see 84.
If the staff pattern is not there, say that it's not there.
It is not, at least annexed here.
So then, how do you establish your
I'll just
This was one of our questions.
I'll just show you a lordship. Kindly give me 1 minute. 63, 64.
63.
Yes. I was sorry,
660. Who signs it?
The secretary of the madrasa.
Has any government officer signed it?
No one has questioned the.
Has any government?
No, it has not.
Where is the order creating the posts? That the secretary and the headmaster cannot create?
That has not
When
been.
is that?
That order is not here. I cannot show you a lot.
How then you prove your case? That according to the staff pattern, appointments have been made keeping in mind reservation also?
These vacancies, though it is not indicated here, these vacancies were a part of the initial selection process, which was, my lord, questioned. By, my lord, throwing a challenge to the rules.
Answer to our question?
No, I don't.
You argue in your own way. Where is the assistant teacher in physics or science vacancy in this document at 63? Where is it?
Please see a science and maths group.
Yes.
Approval date and relevant things are there. Vacant, 5 to 9 are vacant.
5 to 9 have not been approved.
It,
Where is the approval? 5 to 9, if you see column number 1, 2, 3, 4 at the top, approval number and date.
Yes, that is
So
blank
for
here.
5 to 9,
It is blank.
is there an approval number of
It
days?
is not. I am not finding.
Not there.
It is not there.
So 5 to 9 should not have been included here at all in this document if there is no approval. So science and maths group,
There were 4 posts.
four posts all filled up. First one was 1980. The second one, the last one is 1/11/2013.
My lord.
So all posts were filled up, right?
Yes.
And if at all, you could have been appointed against the post held by Indranil Ghosh, who resigned on 1/1/18. Right?
I could have.
If at all.
Assuming.
So, what is your qualification?
My qualification, is also indicated. Just give. He is MSc.
His qualification.
What is your qualification?
Page 57 to 60.
Tell us what is your
It's MSc. With a B.Ed degree.
MSc B.Ed.
Yes.
Right. You were appointed as what teacher?
In physics.
In physics.
My certificates are at page 59, 60, BSc Honours. Then MSc examination 2016 is at page 61.
You faced the selection committee?
Yes.
Who were the members of the selection committee?
That is also a part of this.
Tell us.
No government nominee. It is not there. In the rules, it is not required.
Not required.
Kindly see the rules. Please see the rules once.
Let us see the rules.
First submission.
Before that,
Yes.
was the names of the selectors communicated to the DI?
It was. Apparently it was. Just, may I show the rules first? Or your lordship wants to see that document first?
Yes, that you have conveyed.
Please see page 85
of this affidavit.
of these applications.
85.
These are documents seeking post-selection approvals, not pre-selection. It cannot be pre.
You understand our question?
It is not pre-selection.
We don't have the document.
It is not pre-selection.
Why are you showing 85?
85 is a post. No, it is no. It was not there.
Not there.
Not there. Now, please see the rules.
Very good. Let us see the rules.
Now, please see first. I request your lordship,
You are referring to 2015 or 16?
this will be, all these selections will be by 16.
By 16.
Why, I will just show you a lordship. Well, please see first.
This will be by 16 because you are appointed in 2019.
My lord, please see.
And if at all that gentleman resigned on 31st December 18.
Yes. Well, kindly sees the rules.
Yes.
Selection committee. Rule 5.
Rule 5. Yes.
The appointment shall be made by the Madrasa Managing Committee, which will frame the norms and selection procedure at least 3 months before the written test and interview of the appointment in question, and the same is to be communicated to the office of the DI, additional DI concerned, and the director of Madrasa Education. Each thing complied.
Where is this compliance?
Post selection. It does not say. Committee has to be communicated.
Mr. Bhattacharya, please read the first line.
The appointment shall be made.
Frame.
Which will frame the norms.
Frame the norms and selection procedure at least 3 months before the written test and the interview.
The Lordship is saying that norms and this procedure has to be communicated.
Yes, and the same is to be communicated.
Yes.
What does same mean?
The norms and procedure, it has to be related.
It has not been done.
Apparently no. At least I don't find anything from the records. What I can't find, it is not there. It is presupposed. But what is there is, there was a selection committee and I participated in a written test, and thereafter,
What we say is strengthened by the last sentence of this para 5. The Madrasa committee shall also constitute a selection committee
the purpose of
intimate the same to the concerned inspector.
At
the same time, while you devise what would be the modalities for selection, you will also have to inform the manager, the DIF group, who are the selectors.
If I put it this way, with greatest of respect, this can be, it is not saying it has to be together. Your Lordship is saying that. Let us assume, whatever is falling from your Lordship is correct.
Para 5, so it has to
whatever is falling from your Lordship is correct. I take it, for the benefit of the litigants, that this selection took place and simultaneously, this selection, everything was informed to the DI for onward approval. And in fact, it is my duty to point out to your Lordship, that the state, in the facts of this present case, may not be this case, has been accepting, these sort of appointments. They have also released money which are a part of my writ petition. They have approved, a large number of candidates also. It is not that the state has not
equality.
Not negative. How can they pay fast and lose? One candidate they are saying that this is not done. In the other candidate, they are saying that they are going to release the money. In the teeth of a contempt proceeding.
If at all a co-warrant is maintainable against them, file a co-warrant.
Not that. I am also saying,
otherwise, in view of 1995-705, Chandigarh administration,
they cannot. May I answer you, Lord? We are trying our lot. It's not that, kindly, we are trying. Essentially, we are trying, There are orders passed by the, what is the trigger point, The trigger point is the challenge thrown to the rules. Had the rules never been challenged, these persons might have sailed through a selection process. The rules were challenged. The High Court wanted the state to come to the rescue of these persons. The High Court wanted the state to intervene. The state having not done so, the High Court by an interim order during the pendency of the matter before the Honorable Division Bench, by a Division Bench presided over by the Honorable the Chief Justice, directed that in the absence of the state devising any mechanism, the madrasas will be at liberty to do so. And thereafter the madrasas, of course, I cannot sustain this because this is post 2016. Now, here, please see, request my lords to kindly see paragraph 10 of these rules or rule 10.
Yes.
No prior permission shall be required for advertisement and starting the process to fill up any vacant post duly sanctioned by the state government. Now, my lord, I am a candidate. I look at an advertisement. I offer my candidature. The concerned madrasa calls me for a written test and an interview, followed by a process. My lord, it might not, my lord, appeal to your lordships, my lord, having regard to maybe Article 14. But my lord, kindly visualize the situation of a candidate. He is not at fault by any stretch of imagination.
He's a very well qualified candidate.
An MSc B.Ed.
Why is he not appearing in the examinations conducted by the School Service Commission?
That I do not.
Not.
How can, I mean, he must have, I do not know.
He has got this appointment somehow. So
Not somehow. Kindly these, these
words. Degree holder, when he knows that his appointment is under a cloud.
His appointment is not under a cloud, my lord.
Submitting that 5 has not been compliant.
I have, according to your lordship, I say.
No, not according to me.
You
have just now pointed out paragraph 10. Please see, come to paragraph 10.
Yes, paragraph 10.
Prior permission will not be required, provided the managing committee
Sanction.
the terms and conditions as stated in these procedures are fulfilled.
Yes.
That is the fulfillment of 5.
I put this question to myself.
That is the fulfillment of 5.
I put this question to myself. Where does 5 say that these persons need to be a part of the selection committee? It grants
not required. Managing committee may appoint anybody. 1, 2, 3, 4, 5 or 1, 2, 3. Anybody. But that has to be communicated. The norms have to be communicated because in case the district inspector finds that something is being done by the managing committee, which is not within the four corners of these regulations, the TI can put a spanner in the works saying, look here, this is where you are faulting, here you are defect.
I put this, in my way.
We are not saying that A, B, C, D are selectors, their names have to be, you have to, who will be nominated as a selector is entirely within the prerogative of the managing committee. Their names have to be.
I am trying to answer your lordship in my humble way. Kindly visualize the selection. Your lordship is Rule 5 obliges the madrasa to inform the DI. It has not done so. Let us go by it. There is nothing in these rules which say that the government nominee is a must in the absence whereof.
Saying that once you have satisfied us that the government nominee is not a must,
yes,
we did not ask you.
No, so therefore, your lordship is only on the norms. Today, a person participates in a selection process and is ultimately sailed. He sails through in the process. Ultimately, if that process is found to be impinged only on the ground that the norms were not communicated, is it not stretching the rule, too wide? With all humility,
Prior permission is being dispensed with on this understanding that the managing committee will follow the rules. So managing committee is being asked, look here, once you take step 1, step 2, step 3, you keep us informed. Why? There must be some object behind.
My humble.
Today, if they say that these are the selectors, and the DI find that one of the members of the selection body is a criminal. He will be allowed to continue as a election body member.
That is also covered by judgments of your lordship's court as well as by the High Court.
Hypothetical case, knowingly, unknowingly, we do not know. But DI finds out that the
antecedents are bad.
He will be allowed to continue as a member.
Good, sir.
And can you say that I am absolutely pure, clean? But if the authority has done something wrong, why should I suffer? You have just now seen NEET examination has been cancelled. Right?
Yes.
You think that all the candidates got access to the leaked question papers? No. Only a few may have got it.
And that goes for all selection. Even the 26,000 selection is also a subject matter of that.
The sanctity of the process has to.
Here your lordship is, the sanctity is not in question. Kindly, it is a question, which was raised in the contempt. It was not, kindly pardon, mass. The rules were under challenge, the rules were set aside. at the material point of time, since the madrasas had to run, this 4th March or 3rd March 2016 was promulgated. And in this reference is there to 9th February 2015. 3rd March 2016 and 9th February 2015 became the sheet anchor of the entire process. And in the...
Mr. Bhattacharya, along with you, how many competed for this?
in this selection.
Where are your statements as to what was the process devised by the managing committee for selecting the
No, the managing committee will be able to answer your lordship. Though the managing committee, my lord, today's managing committee takes a stand. In some of the cases, your lordship will be surprised because, my lord, of severe loggerheads with each other. The present managing committees have gone to the Justice Day committee and have submitted that the selection did not take place. In some cases, or maybe in this case also. Because, my lord, of the animosity inter se parties. As a consequence whereof the victim is the concerned person and none else. The managing committee and or its members have nothing to lose. They take a stand different, though it is their communication made to the DI, seeing that this is the selection made. Now that statement perhaps your lordship will not get.
Not there, we are looking for something.
85 is the communication which has been supposedly given to the DI. Your lordship may have 85. The document is dated 31/12/2019.
31/12/19, right?
And then there is a stamp, your lordship may see. This is delivered on 18/2/2020.
Correct.
2-3 months. In between is the judgment of your lordship saying that earlier appointment is saved if it has been done through proper channel. Why this 3 months? Because the judgment came on 6/1/2020. Rafiq judgment. So 3 months after, this document goes there that I have complied with the rules.
No, so he is relying on, not the 6th January and paragraph 60.
Reading the document. I am just reading the document. I am not denying anything.
Here,
And it is, my lord, with all humility, my lord, importing something which is not there.
where is your appointment letter?
Then, my lord, in the application, it is there.
This particular application, where is your appointment letter?
My lord, in the main petition. It is not there in this application.
So where is it?
My lord, date of joining and everything is recorded in this 31/12/2019 communication.
When is the appointment?
My lord, just gives me 2 minutes.
This is 15th of February.
After the judgment.
Vicky.
15th of February 2019.
No, 2012-19, page 45 of an application, my lord, seeking to bring on record additional documents. Now, this is my app. Yes, इसके page 45.
10.
This petition, which is the complete.
Page 45. Application seeking to bring on additional documents. So it is there in page 30. Case for us.
Your petition takes in the.
This is wrong. Though. This is wrong.
10.
On the 20th December.
10. Of your petition.
Sir, the 20th December 2019. Instead of 15. Maybe it is 10. one thing, the findings of the Honorable Justice Day Committee, my lord, insofar as I am concerned, my lord, that is, the appointment letter is at page 45 perhaps. 30, I'll just find it. 45, 46. No, I'll just find it once again. Yes. 45 is my appointment. Qazi Muhammad Jahirul Hasan. 20th December 2019.
Wonderful. Wonderful.
He was.
কি হয়েছে ওইটা দেখো সইয়ের তলায় ডেটটা দেখো কোন সালে
2019 has not come up.
What?
19 has not come up. 2019 it should be.
Mr. Bhattacharya, it says 2012 2020 when he has signed it.
This 20 has not come. It has 19 should have come. 19 is missing in the Xerox, in the photocopy perhaps. In this.
How do you know it?
The date on the left hand side.
Left hand side may have been there.
In the
We will go by
the previous communication, previous letter.
You have supplied this document which shows 2012 20.
2012, 2019. It should be 19. 19 has missed. This is 19 here. Kindly not. Why should I disclose some? Xerox photocopy has not come.
Very well. What is there in the first line? Wide meeting number. What has now not been printed? First line.
9/19.
September 19.
No, the meeting number is 9. I am not appearing for the. This is the reference.
No, if the authority does not come and support you, you will have to stand on your own feet.
The authority has said something. I want to invite your lordships to that also. And they have also referred to an additional post memo in this letter. If your lordship kindly sees,
Additional post memo, where is it? 7th of October 13?
I cannot produce it. I don't have it. It is for the committee.
Because yesterday one such memo was shown to us.
Maybe.
You must have heard while you were joining virtually. So where is the memo? You are coming with a case for a mandamus to be issued.
Yes.
So how
that case? I ideally don't have. Ideally don't have. I cannot.
Very well.
Only.
And see this.
Please allow me to show your lordship two more things before I say.
Page 85.
Yes. 85 of the application.
Mr. Shamsad has shown us that this was submitted 3 months later. 3 months later, all of them have joined on the same day. They don't join all of these.
Everything cannot be, the date of joining cannot be, again, in that event,
Thank you very much.
Only two more things I need to show you, lordship. Just, since, I'm taking two things. Please come to, the principal writ petition, page 428. The writ petition that was filed. The findings of the committee.
We are not on the findings of the committee. We are on our own findings.
And reliance on,
if we were to simply rely on the findings of the committee, we would not have framed these questions. Why have these questions been framed? Why have we asked 10 from the teacher side, 5 from the non-teacher side to give their...
Correct. Only this.
No, it is only for the purpose of convenience of the court
only
that the state government has prepared this chart also with the recommendation of the committee.
Only one thing, if I may just only invite your lordship, please pardon me, 385, that the comprehensive report of the committee, 385, reports were specifically solicited, those reports were never disclosed. At least I should be knowing what is against me. That kindly,
Next matter. Next.
As your lordship.
Thank you very much.
My lords, perhaps my matter is not in the chart, but I have a state's document which I have kept a Xerox. I think
What is your name?
Shrija Chaudhary, my lords.
Not you.
Oh, I'm so sorry. Mine is, I'm so sorry. Mine is 35.1, Mir Musarraf Hussain, my lords. Office report, it is on record, my lords, and
Do you have any document about him? Mutalib Hussain?
I had forwarded to the nodal council also.
There was a chart which were made for all the candidates who are here.
Yes.
So they are in 3 volumes. So from there we can, because
Yes.
my learned friend is saying that she is not in that chart and out of that 10.
Not in the chart.
So we'll have to go to that larger chart.
This is, my lords, the document which was filed in a compliance affidavit where the state was directed to.
So after we said that particulars of 10 candidates be furnished,
Yes.
was this name furnished to the?
Yes, because we had filed it. It is in the office report. Perhaps it is. There has been some miscommunication. It reflects in the
So
case.
we have been hearing this matter from Tuesday.
Yes, ma'am. I have served them a copy of the. I have.
Just told them that the Nodal Council could have prepared your particulars.
My lords, it's, I think, already prepared. It is a part of state's counter affidavit only, which I have taken Xeroxes.
This is come only on Friday.
What is this document you are showing?
My lords, just a brief history of the context. This is the document. Yes, my lords. This document was prepared by the state when the state was directed to file as to who all are working currently in the madrasas. So the DIs created a report to assist the state. So they had prepared this report for all the schools and all the candidates who are present. So I have just pulled out for my candidate, and it perhaps addresses, my lords, all queries.
Very well.
So that's what I am referring to, my.
Paragraph, serial number 6.
Just a second, my lords.
No.
Yes, yes. 1 second. My lords, that
Serial
compliance.
number 6 of this document.
Yes, my lords.
Page number 334.
Yes, my lords. If the intimation was given, my lords, I'll start with arguing the case against me like a devil's advocate, because what is there, what is not there, I cannot modify.
Yes, number 6.
Yes.
Because we have heard other learned
If the
counsel.
intimation was not.
So number 6, you are suffering from the same disability as the 2 candidates represented by Mr. Bhattacharya. That's this intimation which was required to be given under 5 of 2016. That has not been furnished. So this is the case that it is not furnished. Now, if you want to assert that it was furnished, show us documents that this was the procedure which was devised by the managing committee in a particular meeting. These were the names of the selectors, and this was communicated to the district inspector of schools
Yes, my lords.
3 months before the written examination.
Nothing is on record to show that.
Is on record.
My lords, I'll just take, my lords, to one document.
If that is not on record, madam, how do you sustain?
I'll just take, my lords, to one document which is in my compliance affidavit, my lords. Give me a moment. And my additional documents also.
Yes. It's a chart note. 3-volume chart.
But is it the same?
Yes, my lords, Nodal Council's chart, volume 3, page 12, page 11 and 12.
If the left,
Yes. Volume 3.
refer tell me, wait,
My lords, page 51 of this.
ये दीजिए, if this step.
Page 11. This here.
11 and 12. Not ours, theirs. Theirs.
Of your affidavit in compliance,
Yes, page 51, my lords.
page 51.
This is a memo dated 24/7/2017. The district inspector of schools writes to the directorate that submission of report regarding alleged appointments of 2 assistant teachers and clerk. I am the clerk here, my lords. I am the group C and I was appointed on 8/5/2015. It writes how the procedure was followed for the appointment and it writes the sanction post also, and there is a vacant sanction post for the non-teaching. It says there was no prior permission, paper advertisement, and it asks back the madrasa that where is the advertisement? The madrasa in, I'm sorry, my lords are reading. Plus, in the I will show the appointment letter also, my lord, where there is no mention of advertisement. He was under some 10% management quota.
Did you get that 10% management?
My laws in Rule 2015, clause 6, which suggests that, my lord. I'll just take that. My lords, it's in page 41 of my additional documents.
41 of the.
In the main writ petition also, my lord, it's there. Some part was missing, so I have filed it again in the additional documents. It's the original.
This additional document or affidavit in compliance?
Additional documents, my lord. It was filed much prior. My lords, I may just read it out. I will, if that is all right, my lords. Page 41. मोटा होगा, not this. हाँ, that one.
2015, we have it separately. Yes.
Yes, my lords.
Which clause?
It's 42, clause 6, my lords.
So how many competed with you?
I have no idea, my lords. I will fairly submit that.
So this does not mean.
I know, my lords, what is falling for, my lords.
Maintained. 16 has to be maintained.
Yes.
But this is an identified source.
Yes.
That in 10% only Muslims will be appointed.
Yes, my lords.
So not only one Muslim that you are representing.
Yes.
There may be other better qualified Muslims. Why have they not been considered? There is no advertisement. That does not mean that you only consider one.
I bow down, my lords. I cannot change, my lord, what has happened. I am just showing what is my appointment letter is only. I'll show my lords the appointment letter once moment. Just a second. The appointment letter.
Yes, your appointment letter.
My lords, it's in the main writ petition, annexure P 117. There are many caveats to my appointment letters. 117, my lord, so sorry. Appointment letter and the joining letter. They say that it is under the rules. Then they refer to that interim order, and then they again say that this is subject to the outcome of the court. Yes, my lord. Where I am standing, my lords, I rather don't have much grievance from the state than what I have from the managing committee and the school, that they have promised me. And
So very well known to the secretary
no, my lords.
that the managing committee decides on 8th October that you will be appointed. The appointment letter is issued on 8th of October and the joining is on 8th of October.
My lords. Joining is 14 perhaps, my lord. My lords, I will also bring to your notice as to why this is.
118.
Yes, my lords.
What is the date at the top? 14th October.
No, my lords.
I do hereby join
Yes,
as
my
a
lord.
clerk. So everything happens in one day.
Yes, my lords. I have to come to my lords very clean. I asked this question to my client also. As, why, what is this? What has happened? Thereafter, he showed me his documents, my lords. So he happens to be the alumni of the school. So that is what he has clearly stated to me, that he has seen in the notice board while after he passed out his 12th from here, and then that is what is it. My lords, I have one grievance here. That's what I want to speak out, my lords. I am not as much aggrieved from the state as I am from the school, my lords, because it was the school where I studied for so many years that assured me that, all right, fine, you work with me. As on date, I am still working with the school. He is not more hurt on the fact that, you know.
Such a conscious person, you should know the.
No, my lord.
What the fundamental rights are. Your fundamental right, somebody else's fundamental right.
I bow down, my lords.
This is not the way one gets appointment in a quota without giving somebody else a chance to compete with you.
I bow down, my lords. What I am saying, my lords.
Sir, the managing committee will pay your salary from their own pocket.
My lord,
You, not from the public exchange.
2015 Rule 14, your lordship may have a look at it on this submission of my learned friend. 15, Rule 14.
I have
Rule 14.
That is what where I started my lords. I am arguing against myself.
Rule 14, Clause 15, no 14, sorry.
Clause 14.
Yes, yes.
The head of the institution or the secretary.
She's saying that she's not as much aggrieved against the estate as much against the school. So there is a provision.
Because, my lords, what.
That is what we said without even looking into 14.
My lords, my lords, it has happened in a similar matter also.
Let the secretary who appointed you pay your salary.
My lords, I am because I am been given false promises at the instance of the state, which has been happening.
State has not given any promise to you.
No, that is what I'm saying. I am being given promises by the school at the instance of the state. That's
at the
instance of they are saying.
At the instance of the state, where do you find, madam?
That is, my lords, I am a clerk. What has happened is, my lords, he has been promised a job. Then once it is approved, then it will happen. That is what my case is, my lords.
Anyone else?
My lords, I am just submitting the judgment of Jago, which my lords is aware of, and another judgment, if my lord permits me.
What is the other judgment?
My lords, it's a judgment in the facts, it's a two-judgment judgment, in that even though, my lords, it says that he's a principal, he worked in the school for 24 years. It was later on found out he happens to be a relative of somebody, and it was beyond the rules. However, he had worked for 24 years. Therefore, at least that should be considered for his pensionary benefit. That is the judgment, my lords. It's a small issue, my lords.
Give the
My lords, and another.
copies of the judgment. Citation.
Yes, ma'am. My lords, one more small.
Citation.
Yes, ma'am. I have the hard copies of the
But
judgment.
we don't require hard copy. Just give the citation.
1 second. It's a. Served the copy also, my lord. It's 2022. My lords, another submission, if my lords may record. My lords, I have copies of Jago also. I will give that.
Please give.
Yes, my lord. Ma'am, another small submission what I wanted to submit, my lord. At this stage, my lord, the school has taken a U-turn while they have made such promises. I have documents to show that I have been working till date, but still the schools have taken a U-turn that no, now you have never worked. What hurts the petitioner the most that you have never worked. He has given a contribution whatsoever may the appointment process be. What is hurting him that how can you say that you have never worked? Even the committee report says that you have never worked. That is more, I feel that he sees that it is hurtful. So the Jago judgments also, my lords.
Standard senior counsel for state, we are extra players.
Without troubling your lordships on merits, because over 3 days, your lordships have gone through in great detail. There is nothing useful to add. I only wish to point out 2 things on behalf of the state. One is that in these proceedings, the state has played a merely ministerial role in the sense that your lordships have, with respect very rightly, kept this process state-free in the interest of fairness. That's why your lordships appointed a retired High Court judge with 2 high-ranking officials. The state has only given effect to the report of the Day Commission. Beyond that, the state has no role to play, my lords. The only submission which I wish to make, my lords, not just on behalf of the state, but as an officer of the court, is this, that your lordships have been hearing over 3 days this batch of 48 writ petitions, 32 petitions, and before these 3 continuous days of hearing, there have been at least 5 or 6 hearings before this bench where modalities have been sorted out and chart, etc. After investing so much time, my lords, your lordships are going to proceed to write an order or judgment. The anxiety is only this, my lords. Please do not treat these as Article 32 petitions at all. Your lordships have, in the interest of fairness, and I submit very rightly, because in that contempt petition, under Article 142, your lordships devised a procedure, a unique procedure, because it involved fact-finding, which this court could not by itself do. So, in a sense, there was a delegation. Since there was a delegation, the court could not have left the parties fully in the lurch without a remedy. The parties therefore had to have an opportunity to point out to the court if there were any glaring errors. To that extent, my lords, I respectfully submit, your lordships are scrutinizing the Day Committee report to see if there are any glaring errors. So therefore, though these are styled as 32 petitions, ultimately your lordship may treat these petitions as objections to the Day Committee report, which your lordships have considered in detail. Otherwise, treating these as 32 petitions would set an unnecessary precedent
in some future case, again, there may be a complicated set of facts. Again, this court may have to devise an unorthodox remedy. Therefore, Lords, I would only request my Lords Millers to keep this in mind. Lords.
This you can just answer.
Yes, Mr. Ahmedi, any opinion?
Yeah.
You can just say something.
There is a convenience compilation of affidavits of the state in respect of which would your Lordships want to have this without having to wade through other things or whatever is.
There are two compilations. One is affidavits and counter affidavits and witnesses. You have the pleadings. After your workshop order dated 19th of November. The other compilation.
These are no new documents.
No. Everything on record, just culling out minutes for.
The two OMs and the acts.
Well, I respectfully.
Yes, Mr. Ahmedi.
Come. I respectfully, my lords, adopt my learned friend submissions. In addition, my lords, I just want to add two things. Your Lordship will only note that in this list of 10, serial number 2, 3, 6, 9 and 10 are, my lords, appointments which are made after 14th of March 2016. 14th of March 2016 is an important date because the order passed by the division bench was stayed by your Lordship on 14th of March 2016. Now your Lordships took a tentative view in an order which was passed by your Lordships on 18/8/2025, which I may just hand over to your Lordship. Well, let's please see paragraph 6. Paragraph 5 onwards, if I may just place that. Attention was initiated for contempt of the order dated 6/1/2020, whereupon the order dated 2/2/2023 as aforesaid, disposing of the contempt petition came to be passed. There have been multiple unsuccessful attempts to have such order recalled and reviewed. As pleaded in the writ petition, even a curative petition is pending. In so far as the present petitioners are concerned, they claim to have been appointed on different dates in 2018 as matron and night guard of the concerned madrasa. Looking to the fact that the order of the division bench under challenge before this court was stayed by an order dated 14/3/2016 and ultimately set aside on 6/1/2020, it defies logic and reason as to how these two petitioners could have at all been appointed in the interregnum, and that too without there being any semblance of a recruitment process that conforms to Article 60. Now, unless, my lords, your lordships are persuaded to revisit the tentative view that your lordships took, all these persons, my lords, must fall under the same category. So this is an added point, my lords, which I wish to make. The second aspect is, my lords, your lordships have seen the two notifications. First is the notification of 9th of February 2015, which had been interpreted. According to me, my lords, a meaningful reading of 4 and 5, read along with the annexures, stipulates the entire procedure. Your lordships have seen that, my lords. Your lordships have already gone through it. I can just revisit it very briefly. It's very clear, my lords, that that procedure has not been followed. Now, my lords, I just come very briefly to the submissions made at the bar. My lords, the first set of submissions were made by my learned friend Ms. Maninder Acharya. And apart from everything else that was pleaded, she had also tried to place reliance on Uma Devi. Now, my lords, Uma Devi on the face of it doesn't apply because the day committee has come to a categoric finding. Unless they impugn that firstly their appointments were totally illegal, and second and most importantly, that factually her client had never worked. She was at serial number 9. So therefore, Uma Devi is applicable to a person who has continuously worked for over 10 years. Here the finding categorically is that shade never worked. Now, my lords, I come to briefly, my lords, Mr. Bhattacharya's client. My learned friend had been at pains to point out certain aspects of dates of appointment, etc. And my learned friend had also pointed out, but the pleadings in the writ petition are very different. Your lordship sees his serial number?
10.
Serial number 10, if your lordship goes to the chart, because the dates of appointment that my learned friend was seeking to point out do not kind of match if your lordship sees the pleadings in his writ petition. Just see the first column. But here, what is this? Yes, approval was granted on 15/11/2018 and his appointment was on 15/2/2019. Paragraph 10(2). So again, my lord, somehow the dates don't kind of match to what is sought to be suggested to your lordship.
We said that 14/3/2016 is an important date because the implement order was late.
State. So your lordship.
So what was the, what did you say?
2016.
14th March.
Not the rules which your lordship is looking at was promulgated on 3rd of March 2016.
So when was the division bench order stayed?
Not in 2015.
No, 14th of March 2016.
Our order, they have recorded the date wrongly.
No, but that's
Division bench's order, Acha, division.
Division bench's order stayed by the Supreme Court.
yes, 14th of March 2016.
14th of March. So, what would be the effect of this stay order on 14th of March?
Yes.
Therefore, does the Act revise?
The effect of, my lords, the stay order would only mean that the striking down of the Act as being ultra vires is state.
That is state.
So therefore the Act would revive.
But did the court make any observation as to how,
No, they,
in such time the appeals are decided, how the appointments are to be made?
no, not in that order, nothing like. There was an IA's mode, etc., saying protect us or whatever, and some individual cases.
Is there any compilation of all the orders passed by this court, right from 14th March 2000? There have been several orders.
We can furnish that, my lord.
Just furnish all the orders.
We'll
Orders passed by
Yes.
this bench.
Yes, but my lords, your lordships are right in the observation that was made. Because if there is a stay, then there is no question of making any appointments in the interim, unless express permission of the court is sought.
Was that 14th March 16 order? Is it readily available?
You got it.
Because the single bench's order merges in the division bench order.
Yes.
What survives is only the division bench order.
Yes.
Now that division bench order is telling
Page 88 of WPA 641. That is serial number 31, 35.31. Situna Tadrin.
hand over the file. Hand over the file.
14th March 2016.
ये दिखाओ एक। there must have been some appointments made in some madrasa in terms of provisions other than the Madrasa Service Commission Act. Then the division bench passed the order. 14th of March, it got stayed. Before that, some appointments may have been made.
Yes, in terms of a division bench's order.
14th March 2016 order and 10th May 2016 order.
My lord.
Is there any order passed by this court permitting any of the madrasas to make appointments?
18th of May 2000, 17th of May 2018, what happened that when this matter remained pending for 2 years after this stay order, then a lot of requests were being made that the position is vacant. So a specific order was passed. 18th May 2000, just 17th May, this is part of, my lord, Commission's counter in the lead petition 566, WP 566. We have filed a counter affidavit on behalf of the Commission, and in that counter affidavit, it is at page 35.
In your book, we find an order, 4th of December 18.
No,
Contempt petitions were filed because the 10th May 16 order directing release of salary was not being complied with. So this court directed that it is open to the contemnor so is in case the order is not complied with for no reason. Following contemnor shall remain personally present. In case of non-compliance, state shall file an affidavit. This comes from so. After 14th March 2016, is there any order, Mr. Bhattacharya, permitting appointments to be made?
My lord, 17th May 18.
17th May 18.
Let's see that order.
That's the
Order copy.
So 17th May, perhaps not here.
It's in the Commission's counter, which I have just given the number. So we can read it.
Can I read it slowly, Malad?
17th May 18.
Yes.
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 After hearing learned counsel for the parties at length, and particularly considering the interest of education of children, we propose to pass the order. It was stated that more than 2,600 vacancies are existing in the madrasas. Due to shortage of teachers, the cause of education is at sufferance. Considering the fact situation, which has been created by the legal embroglio in the case, we deem it appropriate to pass this order relaxing the earlier order, putting a restraint on the declaration of result with respect to the recruitment process initiated in the year 2014. It was submitted before us by counsel appearing on behalf of the appellant and also supported by senior counsel appearing on behalf of the state that madrasas which are willing to appoint may be permitted to appoint the incumbent on the basis of the selection made by commission. Prayer made is reasonable. It has become very difficult for various madrasas to impart education in an effective manner due to large number of vacancies which could be filled up for several years due to litigation in question. At the same point of time, it was pointed out by counsel and other learned counsel appearing on behalf of the incumbent who are working in madrasas that they have not been paid their salaries in spite of the orders passed by this court from time to time for disbursement of salaries. It was pointed out by counsel that certain incumbents are not found to be eligible. As such, their salaries have not been dispersed. It appears that pursuant to the order passed by the division bench of the High Court, the state government has come out with a notification dated 3/3/2016 prescribing the eligibility conditions for appointment containing educational qualifications for the years for the teachers to be appointed by the madrasa. In view of the notification dated 3/3/2016, we order that in case incumbents who are working are possessing the qualifications as prescribed by the state government in the aforesaid notification, the payment shall be made to them and they shall not be deprived of their dues. Let the order be complied with respect to the payment of salaries, also within a period of 2 months from today, as assured in all fairness by counsel appearing for the state. Even if the teachers had not been paid for the period prior to 3/3/2016, they shall be paid their dues for the period they have served. It is made clear that all incumbents shall be paid their dues in terms of this order, whether they have approached this court or not, and this order to be applied to all similarly stated incumbents. As there are large number of vacancies existing in the various madrasas, we permit declaration of the result for the recruitment process for the year 2014. However, no further recruitment process shall be undertaken. It is also stated by the state government that only those madrasas who want to take the incumbents from the list of the 2014 process, the commission shall sponsor the names only to such madrasas, not to others. The process shall be done strictly and in accordance with the merit list of the candidates and the appointments so made, and shall be subject to final outcome of the case. It was stated that there are certain incumbents who were selected in the recruitment process of 2013 are also awaiting their appointments. Let the appointment be made in the institution which are willing to take such teachers, however strictly in order of merit, that shall be subject to the final outcome of these matters. No equity shall be claimed on the basis of the appointment so made on a stopgap arrangement. Let such conditions be also mentioned in the order that they would be subject to the final outcome of these matters, that they may also be specifically incorporated in these orders. As the case has already been heard in part on several occasions, list for further hearing.
Any order? Yes, there is another order of 13th of 2019. 13 June 2019. That order,
13th of June.
let this writ petition be placed, no, this was in a writ petition.
Not in this matter. Writ petitions kept on being filed, so that's.
Let this writ petition be placed before the bench which has passed the order dated 13 December 2018 in civil appeal number 5808 of 17. That is the other one. In the meanwhile, in terms of the notification dated 3rd March 2016, to which there is no challenge, the process of appointment of teachers on short-term contract basis may be commenced. However, the appointment shall be finalized with the leave of this court.
This order is not made in the civil appeal.
Not in the civil appeal. It was tagged with the civil appeal. Yes.
3/3/16 was introduced at a point of time when the division bench had struck down the order.
Yes.
And the decision on the civil appeal,
my lord,
was yet to be pronounced by the court. After 3/3/16, in May 16, the judgment is stayed.
May 16, the judgment is stayed.
What remains of 3/3/16? What remains of 3/3/16? If you see the recital of 3/3/16,
now please come to 3/3/16, the recital.
Please see the recital.
Now, whereas clause 1, whereas honorable division bench.
It refers to division bench order. Division bench on 9th of December 15 has given liberty to provide appointment to the candidates for empanelment, so and so. Now the governor is pleased to order that since a substantial portion of the final obligations of all, so it was in the interregnum, what will happen? What would be the procedure to be followed? Once on 14th of May 2016, Supreme Court stays the judgment. This is just a piece of paper.
Assuming whatever is falling from your lordship is correct, then what happens to, kindly do not scold me, kindly do not scold me, what happens to Mr. Rai's argument, that regarding paragraph 64, all appointments made during the interregnum were protected.
During the interregnum means division bench order, or single bench order,
then
not any appointment made after the stay was ordered. After the stay was ordered, all appointments are null and void.
That was not, that the original division bench never, held the, with all humility, that was never.
Both of you
petitioner.
Well, I have another,
Respondent side, please give us.
well, I have another matter. Well, just one thing, Milord. Kindly, Milord, that person is also there in that list.
Finish
His name is what? His name is what? Koto number? Milord, I have handed over one petition, Milord, 641.
We'll consider.
Milord, in that, Milord, also, Milord, the persons are all qualified. Everyone is Milord,
When?
in 2015. In 2015,
Of all the orders.
prior to Milord,
To 9th of February order, 9th of February government order.
it is supposed to be, but Milord, I say it is in accordance with the division benches order.
Council is not sure.
Milord, I am saying,
Let us-
Milord, I am answering, Milord, trying to answer your lordship, Milord.
Yes, thank you, Mr. Ahmed. Yeah,
Just
Milord,
one last one. Sorry.
Milord, only one thing. Milord, Mr. Ahmadi has a very good case. Milord, kindly do not shut us out, Milord, after 12 years.
Mr. Bhattacharya,
Malas,
we have to board a flight
yeah,
and we have to get ready for tomorrow.
yeah. Malas, since my learned friend just said that I have a good case, I rest my case.
Milord, he has a better case.
Yes,
There is no doubt about it.
that 101, Mr. Banerjee is there.
Yeah.
I could lay my hand on this is that judgment laws of lordships pointed out the judgment yesterday.
This one is arguments closed, huh?
We just wanted a.
Arguments closed?
Lordship is desiring, Milord, or not?
No. Only the orders. Compilation without the record of appearance.
He's here, Milord, he's going to hand it over to you. Milord.
Very good.
My
Hand
lord,
it over to the courtmaster as soon as it is.
Our note.
Both sides, total council will hand over the compilation of the orders, nothing more. We don't want any written submission.
my lords, if the with permission, as my lord indicated that, the school may pay for, there is a specific judgment to that effect. If I can be permitted to give that.
Yes, the matter is over, Milord. Only one thing may I just say. Only one thing, Milord. Only one. During this entire period, Milord, despite all this, persons are still being regularized and appointed by the state. Very recently in 25 also.
That is why the state has plummeted to such a level which we have never seen.
Now this is. Sir. Yes,
Well, it's, had asked me, had given a direction. I don't want to give it to my learned friend.
You give it to us.
No, I'm not even.
I mean,
Then
Don't give it to
then the
him.
situation may.
Don't give it to him.
And this is for the 4 years, in case we calculate from 1998 to 2002, when that notification came into effect. Else I'm also circulating that. This is the other one. Another calculation, Malad, I'm circulating. This is if it was from 98 to 2002 is when that notification came into effect. So that termination was in 98 and the 2002 was that notification which exempted, Lordship will recall, armed forces out of the PW Prevention of Disabilities Act.
47.
So that's after section 47. That happens in 2002. So if that is the basis of calculation, Malas, then that's the latest chart, which is a small number, which I've sent. A smaller chart.
This notification by which armed forces were exempted from the application of the
Page 47.
page 47 of the main paper book.
Please, Miller, 43 of the main paper book.
In exercise 45, P2,
45.
So 43 also? No?
43 and 45?
43, it's
43, well, let's will please come to 43 and 45. P1 in
Is a desk job.
In
combatant
powers
job, Mr. Solicitor.
hereby exempt all.
Mr. Solicitor.
Yes.
If somebody is assigned a desk job,
Yes.
does he still have to perform the job of a combatant?
Well, then thereafter, well, it's 45.
Yes, we are on 45.
Well, it's 43.
Categories exempt all categories of posts of combatant personnel.
Yes.
Combatant personnel. So you don't have any
Well, it's-
post of clerk, any post of peon in the offices.
Well, he's blind, Malaj.
So,
I'm not saying that. Malaj, I'm not saying that. Malaj, that's not
you
I
don't require anybody to do any desk work.
Malaj, may not be the kind of work which. Anyway, Malaj, we are exempt.
Combatant, that means
Malaj, may I?
field work.
Malaj, may I please, having regard to the type of
You
work.
can't expect somebody who is visually
Only
impaired
on from
to really go to the battleground and fight the enemy. So therefore, this notification
From the
also
provision,
does not come to you.
Malaj, according to us, Malaj, it would not apply to combatant. I mean, he was a combatant personnel, so 47 would not be applicable to him.
Why?
Because he was actually in a combatant category. Because what they are now saying, what the court is now
As a
saying,
physically disabled candidate, you cannot appoint a candidate on a combatant post.
well, it's exempted.
All combatants,
Well, so,
all combatants.
well, so I
So
don't.
You will have to tell us
Well,
that you have only combatants.
No, well, my submission is slightly different. My submission is this, that 47 for a combatant personnel who is a combatant, 47 is exempted. So I don't have to apply
We'll
47.
interpret 47. We'll interpret 47.
Lordship wanted this judgment of Justice Ansari. I just handed over, my lords. On waiver, my lords. Paragraph 26, my lord, it says, where the social legislation, my lords, then if it emanates from there, then no waiver. So good. Can we file my lord, written submission of?
Not required.
Not. I have.
Anyway, we will not be delivering it this side.
No,
So if you want, you can do it by Monday.
this Monday. my lord. So good.
Yes.
We'll put in a.
Or for you also.
Well, if we were just discussing with our learned.
Mr. Gupta and Mr. Suresh, we are here, but we will have to keep it beyond.
Very well.
Mr. Sharma, उसी दिन में दे दें. The other.
When you through lottery, it was latest.
1 minute, one.
Of the gold lottery, participated by appeal direction lottery. And the
When? Monday. The civil appeal.
Yes, no, it's civil appeal. What's the problem is there?
The entire week is miscellaneous week.
Directed this.
He's not seen it.
Are we sitting idle, sir?
Lordship, item 8 was to be taken.
Yes, item number 8, we remember.
Just that,
Yeah, I did.
just one prayer in 8 minutes.
And office report जो है. What does the office?
State has not-
Service has not inspected.
1 minute.
What was the date?
Not the first order. I will explain.
State has affected service, affidavit has not been filed. That's the error. The ad has been made. About 2 weeks ago, there was a problem in the cause title in the affidavit, so it was unable to be filed. We'll file it today. That service
that's
is affected. I know the office report says that. I
That's
just
one
wanted to place
SLP,
that
Milord.
matter.
I have filed an SLP, Milord, the first matter, in which also Lordship said publication in all the matters. While recording, Milord, it seemed as if only in one SLP publication was ordered. So registry did not give me that.
Section 8.
Item 8, order dated 9/4/26.
It is recorded in the office report.
It's there in the.
Yeah, in the office report, your Lordship will see that. Today's report.
Lordship kindly takes the office report.
இதுல வந்து நம்மளோடது வரவே இல்லை 30025 to 2 petition this that has not filed affidavit, but there was no order for
Ninth appeal order.
Para 9 of that. Office
Say that it is only in respect of one matter.
No, but registry did not
Taken
give.
by the state of Karnataka
Ha.
to effect service to paper publication within 2 weeks.
Yes, my lord, that was only one matter, whereas we all requested in our matter also same service will have to be.
State is petitioner in only one matter. So we would effect.
State was
service in the matter
SLP
where we are
petitioner in one
petitioner.
matter only.
My learned friend is petitioner in another matter, there they have to effect service. So that
Yes.
small technicality, the registry is creating an issue over.
Tell us.
Lord, we went to the, Lord, when we went to the registrar only, we realized not the registrar.
March, today we are on almost May.
Today they have filed an additional affidavit today.
The state, no, this is something else, sir.
I understand. And my lord, 18, 19.
9th April, my lord, 9th April.
Mr. Sharma, 9th order is ahead.
Sir, office report mentions it. Sir, office report mentions it. Office report will there. I am in SLP number 30025 28 of 24. Harish Kumar. So when the order got recorded, it was like that.
Malad, I tell you, on last occasion, the lordship made it clear that the lordship would hear the state SLP first. Then only your lordship will hear the other SLPs.
It is because of the Gomal lands.
Because of the Gomal.
Lordship may allow us not, we will paste the publication bill.
Sir, how many SLPs are we considering?
3 SLPs were there, but in other 2 SLPs, same thing had to be effected.
You know, see the order of 9th of April.
Yes.
Records Mr. Sibal's appearance in SLP Civil.
That is a state.
That is state SLP. He was for the state.
8248.
Yes, yes, yes.
11 petitions. That means there are 11 petitions by the state.
No, numbers, writ petitions were there.
There are different.
In the High Court, there were many writ petitioners. So there is a common SLP.
The High Court, there may be several.
Yes.
We are asking you how
Yes,
many
yes,
petitions
Lord.
are the state?
48 to 58 is all his. Lordship, you are absolutely right. There are 11 numbers.
There are 11 petitions where state of Karnataka is the
Petitioner.
right?
Correct.
Right. Apart from these 11,
Yes.
there are 3 other petitions.
Yes, my lord. We are also filing 25, 26, 24 SLPs, my lord.
2 others.
Which is SLP Civil 325 to 328.
लिखो तो मैडम जो
30025.
SLP numbers, right?
30025 to 30028 of 2024.
The notice has not been served in these 4 petitions.
In few respondents, paper publication was to be effected on them.
The Pratik Chatta, PAG for the state of Karnataka submits that paper publication is required by the order dated 9th April 2026. So far as SLP civil numbers 28248-28258 of 2024. Affidavit of service is to be filed by tomorrow.
Yes, my lord, by tomorrow.
I need a week.
We seek permission to file the affidavit by tomorrow. First and allowed. We also grant liberty to the petitioner in Madam's SLP's 4 petitions to make similar paper publication
On the answer.
as directed by the order of 9th April 2026.
Yes, my lord.
That is one
English, Deccan Herald and one Kannada.
newspaper, Deccan Herald, and one Kannada newspaper,
Kannada Prabha.
Prabha.
Yes, my lord.
Right, let such publication be made within 15 days
Yes, my lord.
with an intimation that the state's SLPs as well as the other four shall be listed in the week commencing 27th July.
Very well. The interim order to continue.
Any time may be allotted, my lord. This time it was allotted to 12 noon. Today.
We will file our replace the state's affidavit.
Whatever is the slots which are vacant.
My lord, the pleadings will be completed. State has filed 2 affidavits now. We will file our replace
The
also.
state affidavit, the 1890
Very well.
document.
Very well. Deeply obliged.
Today.
Today only they filed it.
Yes, today they have served the affidavit and my lord,
You are getting time.
Yes.
You are getting time.
and my lord, erroneous translation.
Response are not served, affidavit is not served on us.
Which respondent?
Yes.
Item 16,
The affidavit to be reached.
16, it has become infectious.
Item number 16.
Yes, Lordship.
You are for the
We are for the petitioner and final, High Court has already decided the appeal. There has been in
you
progress.
have the order of the High Court.
Lordship, we have challenged the High Court's order which Lordships are dismissed.
But item 16 they did not comply with the last order. Pass this honorable court.
Submit that SLP has been rendered infectious. Is it right or wrong?
No, madam. No, sir.
I have this court's order.
They did not comply with the last order passed by this honorable court. You did.
What is the order?
Lordship, this is the High Court's decision